Morning, everyone. Welcome to the District of Columbia Court of Appeals. We have three cases on this morning's calendar. The first of them is LHL Realty Company DC LLC et al. Versus District of Columbia, number 22 TX 820. And we're here now for counsel for LHL Realty.
Good morning, Your Honors. If it please the court, Stephanie Ann Lipinski-Galand on behalf of the appellant LHL Realty DC LLC. I'd like to reserve 4 minutes for rebuttal, please. Even if this court finds that the underlying 2002 event didn't qualify for an exemption under the DC statute from the DC recordation and transfer taxes, it's clear that the assignment by OTR of a 2019 valuation on a transaction that the event took place in 2002 is an error, and it was unreasonable, and that the statute that OTR relied upon is ambiguous at best and silent.
Can I ask you a threshold question?
Yes,
triggered by your use of the word ambiguous? The parties had debated in their briefs, and supplemental briefs, which were filed before the DC Council amended the DC Administrative Procedure Act on an emergency and temporary basis, about whether this court owes deference to OTR with respect to its interpretation of the statutes and regulations that are at issue. And we'd issued an order asking the parties to be prepared to address the implications of that statute. And in light of that statute, what's your position about whether we owe deference to OTR with respect to the interpretation of the statute and the regulations?
Obviously, Your Honor, the appellant believes that the Chief Justice's opinion in Loper-Bright clearly took the Chevron deference and threw it out the door. I mean, they couldn't have been more clearer in their language. The whole point of the decision in Loper-Bright was the court went through the decision in Chevron, Skidmore, all the past decisions upon which Chevron was surrounded with. Also went and said, we have to overturn this. They looked at the decision at the APA, which the District of Columbia does have an Administrative Process Act, and that helps it forms its regulations and rules and stuff. But it looked at the APA and said, clearly, Chevron was in direct conflict to APA.
Right, and the issue that I'm with you on all of that, but I guess the more specific question is, to what extent do you think the now, I guess, temporary legislation amending the DC Administrative Procedure Act, how does it interact with Loper-Bright in your view? Is that binding on us? Is Loper-Bright binding on us? Are you contesting that we shouldn't pay deference? I'm trying to make sure I understand your position about the implications of the statute for what Loper-Bright otherwise might have meant for us.
The statute clearly says that a reviewing tribunal shall defer to the mayor's office and to the agencies. And that is in clear conflict. Now, it does have a qualifier. It says unless it is plainly, if it's not plainly wrong or inconsistent with the statutory or regulatory language or the legislative intent. Got that. But clearly, this is saying that you shall defer. And that is not what the Chief Justice wrote in his opinion.
And which do you think we're bound by? What the Chief Justice said about
bound by Chief Justice's opinion in Loper-Bright.
And why do you think that?
Very clearly, if you look at the language, the final interpretation of the laws should be at the proper and peculiar province of the courts. In regard to the ambiguities, the Loper-Bright decision made it clear that probably most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving ambiguities. That is a matter of the law. That is a purview of the court. Chief Justice's opinion hit that probably more times than anybody thought he would.
Well, let me ask you the question this way, I guess. I mean, Loper-Bright is in significant part, at least, an interpretation of the Federal Administrative Procedure Act, which obviously doesn't have the language in it that the amended DC APA does in light of the emergency amendment. So unless Loper-Bright is kind of constitutionally driven in some way, it seems murky whether Loper-Bright's interpretation of the federal APA that didn't have this language should control over the DC Council's provision of that language that seems to require deference. So do you think Loper-Bright is like a constitutionally rooted decision that applies and trumps whatever the wording is of the DC Administrative Procedure Act? Is that your position? Or
it is our position, Your Honor, because obviously Chevron is something that state courts have relied upon for years. And they have said, well, we have to give deference. In the state of Commonwealth of Virginia, there are multiple cases in the Commonwealth which basically said the commissioner who for years had deference. Matter of fact, I argued one of those, Coles, in front of the Virginia Supreme Court. And very clearly, the Virginia Supreme Court said Chevron, the deference that is due to, that has been previously due to the commissioner, the state tax department, and its rules and regulations and their interpretation of a statute that is ambiguous and silent as to a particular point, is you can look at it, you can read it, you can be educated by it, but for the Commonwealth no longer defers to the Virginia Department of Taxation. Now, these were all decided before Loper-Bright, but there are consistent cases in the states where they look at the Chevron doctrine. Some of the states defer to the.
So help me with the
agency.
constitutional basis, though. I don't dispute at all. And I don't think anyone would dispute that there were all these state cases before and that in interpreting local administrative procedure acts, relying on interpretation of the Federal Administrative Procedure Act, they'd be strongly affected by this. Is it really that this is now that it infringes on the constitutional inherent authority of courts? Is that why this is an improper decision on behalf of the city council? Is it that city council doesn't have the constitutional authority to delegate that interpretation now after Loper-Bright? What's the actual constitutional basis?
Well, Loper-Bright, Your Honor, because it's so recent, hasn't had time to percolate up through the state courts and the decision that they made and the language that the Chief Justice used. I think it's very clear, though, that if the decision by the Supreme Court as to deference, because states do follow the Chevron deference. And we're more than willing to add an additional brief to show you all the state cases of which tax departments have used Chevron and that courts, the appeal courts have made decisions based on Chevron. That Chevron has been overturned is basically calling into question the deference that courts have been giving to the administrative agencies.
Yes, I mean, I think what the question we haven't got an answer to yet, though, is if Loper-Bright is based on the statutory reading of the federal APA, it does not say you shall delegate, you shall defer to agencies. And now we have a statute in DC that says you shall defer to agencies. Your argument then needs to be, well, that's unconstitutional, which seems, not a question answered by Loper-Bright, but it's unconstitutional. Why? I mean, your answer has to be that it's a non-delegation problem.
It's non-delegation. It's a non-delegation problem, Your Honor. But also, if you look in Loper-Bright, there was a citation to Decatur versus Pauling, 14 Pet 497, and it basically said the judicial role was to interpret the acts of Congress in order to ascertain the rights of the parties. And that's the constitutional issue, whether or not the parties have their rights removed, because in this particular case, much is put on the fact in the lower court's decision in their order that it was reasonable, that the DC's position was reasonable. There was no question as to whether or not to look at whether or not the taxpayer's position was reasonable. Their position was, and there's nothing in the record to support this, that DC infers, and the court says in one of its quotes that, that it basically says that it was the equity, they brought in equity and said it was not, there was no equity in allowing the taxpayer to be able to derive a benefit from not filing when they should. But nobody asked the question, did they have a reasonable belief that they had done a conversion under Virginia statute? They had hired a lawyer from New York City.
Why does any of that matter? It would still be inequitable.
Well,
Even if you had a reasonable belief to think we shouldn't have had to record in 2002 and pay the taxes due on it. I think one of the district's arguments in response is, well, there's no equity in giving you a 17-year free loan by being wrong about that. So you've basically taken this money, you've gained the value of the property as it accrued over the equity in the property for the last 17 years. You've seen what I presume would be massive spikes in the value of that property. You've gotten that money that you should have paid in 2002 as an interest-free loan for 17 years, and that doesn't make sense. What's wrong with that argument?
Your Honor, at the end of the day, they firmly believed that they did not have to file, right?
What, I didn't say anything
And
about, I
that's
said,
fine.
I'm giving you that.
And, but
So
that
it was a
goes-
fine thing to think.
that
But now you've
goes-
had 17 years of a free loan.
Yes, sir.
And you should have to pay it back at its current value.
Your Honor, what they did was the taxpayer appellant could have and agreed to. I mean, if they went in and filed that, because there was a third party sale that was forcing this to a head. And they went ahead and paid the amount that the District of Columbia, the 2019. But they originally came in and said, okay, if you're telling us that this conversion didn't happen and you don't believe this, before they hired me, obviously, they basically said, okay, we'll pay you at the value that it was in the 2000 transaction, because that's when the deed happened. And if you look at the district's law, it says, what is the triggering thing? It's when that conveyance happens, when
Why
that
do you say that?
deed's
Why do you say that?
for
Your
the
opponent
valuation.
argues that if you look at the relevant provisions, there's a different temporal suggestion, which is that the tax is payable upon recordation. And so that you were saying, you take the deed as the event, they take the recordation as the event, and they say that's the event upon which the tax is payable, and therefore it makes sense to assess the tax based on the situation at the time of that event. What's wrong with that thinking?
But they said, if you look at the definition of what we totally agree, Your Honor, that the time of the imposition of the tax is the time of recordation. But if you look at the thing, it says when the deed, and it gives a huge definition as to the deed, right? All the things that a deed could encompass, because over the years, people have basically abused what is a deed, what isn't a deed. And Lord knows DC has enough cases that the Superior Court has gone through this. The issue with this is that the transaction that created the deed, right? The underlying document happened back in 2002, and they were under a reasonable belief that that was a conversion. It's a Virginia company. It was a Virginia General Partnership. It's a Virginia LLC.
I mean,
And
were they, what are the facts that they were of that belief at the time? I thought all the contemporaneous evidence was that they believed it was a merger and that they continued to refer
If
to it
you
as a
look at the
merger.
language, if you look at the language, Your Honor, it said it was going to be converted. Some of the documents, not the statute, not the merger document that came out of the State Corporation Commission.
There is one reference to conversion of interests or something like
conversion
that,
of
but
interests.
the word merger is certainly a more frequent
Used more
and-
often.
and Yes.
Can
Can I ask you a factual question just to make sure? It seems maybe to be undisputed, but I wasn't sure it's 100% clear in the record that the LLC existed as an entity before the transaction in 2002 that brought the company and its assets into the LLC.
At the time of the conversion. So unlike in some of the other
It was
cases
not a pre-existing
where they
entity.
have an LLC that's been sitting there for years, like the Vornado, where they had an LLC sitting there and then they did a 1031 like-kind exchange and they dumped the property in and then they moved it around. At the end of the day.
Can I ask
that-
you, so I asked a very specific factual question. You gave a very specific answer in part, and then you were going to say some other things, but just zeroing in on the specific answer to the specific question. You say that the LLC did not exist until until this document kind of created it, that also merged.
It was
into
created at the same
It
time.
is- well,
Under
and-
Virginia law, you have to file the formation
Right, and
documents at the time that.
And where is that? Can you point me to someplace in the record that establishes that that's the case?
I do not have that in hand, Your Honor. I apologize.
I mean, I think that's a big
Have you ever,
problem.
sorry,
Yeah,
but
no, please.
just, I think that your opponent has consistently argued the case from a different factual premise that the LLC existed as a separate entity. Now, I don't know whether they were specific about it pre-existed, but it existed as a separate entity and then was brought together.
Under Virginia law, when you create that, when you do that movement from a general partnership, because in Virginia, a general partnership isn't necessarily a legal entity per se. It's treated as, they had a federal ID number for it, but it's not, you don't have to go to the State Corporation Commission if you're creating a general partnership. If you create an LLC and you transfer, for all intents and purposes, if you move the content of the general partnership into the LLC, State Corporation Commission requires that you have to form the LLC at state corporation. So it's like you have to create the baseball mitt for them to do the conversion. You can't just say, oh, I'm converting. Oh, and by the way, somewhere down the pike, I think I'm going, or even if you wanted to do a merger, you have to have something to move into. So.
But your position is it did not, other than being a contemporaneously created future form
Yeah.
of the company.
Yeah.
The LLC had no independent prior
It
existence.
had not been in existence, had no, there was no assets, there was nothing, there's nothing there. The creation of the LLC had to be done at State Corporation Commission in order to have the asset, which.
And there was no other, so to the extent the LLC existed, it was created solely for the purpose of being the entity into which
The real property would be moved into.
and it was created contemporaneously, like on the same day, or
I do not
Not
know if
sure.
it was the same day.
and you're not sure whether that the record establishes that, but that's your belief.
Yes, sir.
Can I just suggest that in your rebuttal time, if you have something you can point us to that establishes that in the record? I was unable to find anything.
Okay.
I think your argument becomes a lot more interesting if there was no pre-existing LLC, that this was just a flip of the switch when the general partnership became the LLC. I think it's less interesting, and it looks more like a classic merger if the LLC is established even the day beforehand. For whatever reasons, there might have been tax benefits to that, to create the LLC and then merge the general partnership into that. But I hear you saying, well, no, that's really a legal fiction. It's not a merger. It is a conversion. It's just general partnership flipping over to the LLC. And I don't see any allegation or affidavit or anybody who says that in the record. So if you've got it, I suggest you raise it in
Yes,
the
sir.
rebuttal.
I'm out of time.
Yeah, can I, but we'll give you your time in rebuttal anyway,
Thank you.
and I also like to ask just one follow-up question, wrapping back around to the deference question. The discussion thus far has been about the possibility of taking the view that the emergency and temporary legislation directing deference to agencies in DC is invalid for constitutional reasons. It seems like there would be another potential line of argument about challenge to the statute, which would be a home rule type challenge. You haven't referred to that yet. Is that not something that you have focused on, or is that something that you also have in mind as a concern about the statute?
That's not something we have focused on, Your Honor. The clear, just practical thing is if the District of Columbia and the Office of Tax and Revenue thought that the Loper-Bright decision did not have any impact, they would, because the first emergency statute came out after the decision in Loper-Bright. If they didn't think that Loper-Bright had no impact on them at all, why did they do it? And then why did they redo it again when the first one ran out of time? I mean, it just begs the question.
And
Thank you,
one
Counsel.
minor clarification point, just to be absolutely clear that I understand your argument. Your point on this timing is that with a good faith belief there that your client was complying with the law, we should go back to 2002 because that was when the deed should have been recorded, if this was in fact a deed under Vornado, et cetera. From there, it's not just the recordation at that time, but you would also concede that if we were to find that to be the date, then the interest over the next few years on the unpaid taxes would be applicable as well, right?
There's no provision in that code section as to, and that's why the silence is. There's nothing in that code section or in the related code sections that says if you file late, right?
Mhm.
For any purpose, right? But if you file late, then it's at the time that DC has always said it's at the valuation at the time you file it. But if you look at the statute, unlike like the income tax and the sales tax, that language is very clear. And it says, if you don't file your income taxes on time, or you don't pay your sales taxes on time, there is interest and penalty, and it accrues at this rate, and it does this. There is nothing in that statute that says that this is the remedies. Here's the penalty for what you do. And that's the whole point, Your Honors, is that it's silent, it's ambiguous. If they had something in there that they could point to, then you might say, okay, fine, but there's nothing there. And and again, the Superior Court said, oh, this is reasonable. And the court brings up the equity issue. If there was penalty or something, the court would have had the penalty and the interest thing locked.
I mean, that strikes me as a very good reason to impose the tax at the time of recordation. That it would be an absurd statute. That people get a windfall if they don't record their deeds on time.
Well, that's.
And so like, why would we interpret it that way?
But-
That, if people, you're always incentivized to make reasonable mistakes in your own favor. So if you said a lawyer is like, we could argue that this was reasonable, we could get 17 years free on this loan if we just don't, we could have this, the worst thing that can happen to us is we'll have to pay it whenever we have to sell to a third party. So let's just not pay it now, and we have an argument that that was reasonable.
If,
That seems like an absurd reading of the statute.
if the district then, and again, the taxpayer objected, filed under objection when they had to file for the 2002 transaction, the 2002 event. They objected and they said two things. They said, well, we thought it was a conversion. We had reasonable belief. We hired a New York law firm. We did all that. We had a reasonable belief looking at Virginia law that this was a conversion, therefore exempt from the taxation. That was, nobody asked, was their belief reasonable? And it's the Superior Court that brought in the equity issue, saying it's not equity for you not to be able to do this. It's unfair.
Right, but that was as a kind of as a consideration for statutory interpretation as opposed to like an equitable determination. And in the particular case, the trial court's view, I think, was just doesn't make sense to allow, it wouldn't be an equitable reading of the statute. It would be a reasonable reasoning reading of the statute to allow someone to not record for a long period of time without any consequence, and instead, have the amount that would have been payable at the time of, when recordation ought to have occurred 20 years earlier. So I thought it was kind of a statutory interpretation point. I don't think not a, let's look at the equities in a particular case. And if the equities had been different, we would have interpreted the statute differently. At least that's how I read the trial court's opinion, maybe.
And see, and then the court thought that that was a reasonable interpretation by the department, which then loops us back around to Loper to basically say, should the court have given deference to them on a statute that's silent as to what is the proper way to account for that, for the transaction that occurred with a reasonable belief.
I think
And
I think we have your count. I think,
Loper has
yeah, I
the
think
rights of the parties.
right. I think we have your argument. We'll give you 4 minutes.
Thank you so much.
Thank you, Your Honor. May it please the court, Marcella Coburn for Appellee, the District of Columbia. On the first issue, after this court's decision in Vornado, I think this case is very straightforward. The 2002 certificate of merger is a deed. It transferred real property between two distinct legal entities, from the company to the LLC. It was therefore a taxable event, and the transfer and recordation taxes apply. I think this court could just apply the holding of Vornado directly to this case. It would just need to change the year in which the certificate of merger was issued.
Can I ask you, do you have an answer to the factual question that we were exploring with opposing counsel about what the record shows, if anything, about the existence of the LLC prior to the transaction that also transferred or brought the company and its assets into the LLC?
Yes, Your Honor. I have a couple of answers. And first of all, it is, of course, the taxpayer's burden to show that they qualify for an exemption, and those exemptions are construed narrowly. If you look at page 4 of the supplemental appendix, that's the articles of merger, that is signed by both the company and the LLC. The date that it's executed is February 2nd. If you then look at the next page, which is the agreement and plan of merger, again, that is signed by both entities, the LLC and the company. It's dated February 4th. And then if you turn to the next document in the supplemental appendix, which is the certificate of merger dated February 7th, that again refers to both of those entities, and it's dated February 7th. So I think there is certainly evidence that as of February 2nd, the LLC had signed the document itself. Again, I think it's notable, the contemporaneous evidence, all of this shows that there were these two distinct legal entities, each of whom were signing all of these documents in the time leading up to the time of the merger. So I think all of that shows what is pretty obvious from the rest of the record, which is that here you have two distinct legal entities.
I mean, it's a little, I don't find that all that persuasive. I mean, I take your first point. This is the taxpayer's burden. Indications are that, or at least we have no reason to think otherwise, that the LLC predated the merger. But, the first document you point me to is from February 2nd. It's signed by the same person on behalf of both the LLC and the company. So sure, they sign it as if the LLC. But that's not to say the LLC, that's not to say that's not the first act of the LLC is, and then then it feels a lot more like a conversion. All that's happening is the general partnership is turning into an LLC. And then if that's right, a merger seems like a misnomer.
Two responses to that, Your Honor. First, I think the premise that if an entity comes into existence at the same time the property is transferred means it's more likely a conversion, not a merger. I think that's actually incorrect. In the district's own statutes discussing mergers, it says that in a statute defining the effect of the merger, the surviving entity shall continue or can come into existence at the time of the merger. So I don't think it's like a principle of corporate
Sure.
law.
Yeah, I mean, that's very easy to reconcile though with my view, which is that there could be two companies that are merging into a surviving entity. And so that it just comes into existence then, but there still had to be two companies beforehand. That's, I mean, I could pull out a dictionary to say what merger says, but two things are required to merge. One thing becoming another is not a merger.
That's right. And I think the contemporaneous evidence in the record is still that the surviving entity is the LLC. And I think if you look again at the articles of merger, the plan of merger.
That's certainly true, but I guess and again, I like Judge Deal, I take your first point about who has what burdens here, but just to step back hypothetically, assume that Virginia law in fact does require that in order to do what DC would treat as perhaps permissibly a one-step conversion of an entity that was a company into an LLC, which maybe in DC law you could just say, here's my entity, I'm gonna transmute its shape. It's going to now be a different thing, but there's never was two things. There always was only one. If Virginia law said, here's how you can transmute a company into an LLC. First, you have to create the LLC separate and apart from the company. And then you have to merge, if you want to use it for Virginia, you could use that term and it might not dictate DC law's answer about whether it's a taxable event, but then you have to combine the two. Would you say, and so that it's clear that only as a it was only kind of the formalities of Virginia law that said there will be the vessel that in which the new shape has to be put before you pour the other one into it. You would say that would be a taxable event just because that's the structural requirement where really there never was an actual independent two entities at the same time. It was just like a form that the first entity got poured into so it could have the new shape. You would still say taxable event.
I think it might be a more difficult question if there's a lot of Virginia law about how this form has to take, but it's clear that there aren't actually two distinct legal entities and that there isn't actually a transfer. I think if Virginia law were not clear about that, maybe that could be a difficult question. Luckily, here, Virginia law is very clear about the effect of the merger, and the statutory scheme for a merger is referred to in the Articles of Conversion and the Plan of Conversion. We reference this in our brief on many pages. I'll just read to you Virginia section 50-73.129A. The consequence of a merger is all property owned by each of the merged partnerships vests in the surviving entity. That's exactly the situation that happened in Vornado, because vesting is one of the ways to transfer property under this court's definition of a deed. So I don't think you can look at the Virginia law that actually applied here, the legal consequence of what actually happened, and say that there wasn't a transfer of real property from one distinct legal entity to another. And that's all that this court requires for it to be a taxable event. So I think,
Can I ask you back to you're treating this as the first issue reasonably enough, but there is an antecedent 0th issue maybe about deference or not. And so I did want to hear from the district. I guess you've heard your opponent suggest that the temporary legislation is really not valid, that instead Loper-Bright triumphs over it in some way. And I'm interested in your response to that.
I don't think that's correct. I think this court is bound by the Temporary Act. The Temporary Act doesn't change anything about this court's existing deference precedents under the DC APA. It doesn't change the status quo. The same principles that this court has applied in scores of cases would continue to apply under the Temporary Act. All it does, if it needs to do something, is eliminate any confusion about whether Loper-Bright does apply. Loper-Bright was a decision about the federal APA, and the Temporary Act refers to judicial review under the DC APA. So we think that it doesn't change anything.
I guess I have a procedural question and a further substantive question. The procedural question, which might be informed by the discussion of the substantive question, is whether you think supplemental briefing is warranted on that question, because obviously the briefs of the parties in this supplemental briefs of the parties were filed before, it might have been the reply brief was like contemporaneously with the emergency legislation. So the parties haven't briefed this topic. So I'm interested in the district's position about whether supplemental briefing is warranted. The substantive question is, I mean, I take your point that in its primary thrust, Loper Bright is a statutory interpretation case. But I think it's fair to say that some of the lines of thinking that the court relies on in Loper Bright have, sound in separation of powers or other possible constitutional principles, which have potential application in DC, although that's complicated too if we're not in Article 3 structure. Do you think there's really nothing in Loper Bright that it has any constitutional underpinnings and it's all just a straightforward statutory interpretation question? Or would you agree that there are some strands of thinking that seem to raise some constitutional topics?
Well, I think Loper Bright was a statutory interpretation decision about the federal APA. If this court wants to get into issues of construing the temporary act, then of course we would want the opportunity to brief those questions. I don't know that any of them have really been preserved. As you said, the court brought the temporary act to the party's attention, but even in the supplemental brief about Loper Bright, what's raised is 2 sentences essentially saying Loper Bright applies to this case. The temporary act, we think, answers that question. This court applies its usual deference principles. And again, especially on the first question, but I think also on the second question, we're dealing with the plain text of the statutes. So I'm not even sure we're getting into issues of ambiguity or deference. But again,
That's a good transition to the second topic. I mean,
Sure.
If you have one more thing you want to say, I was going to take us to the second topic, but
Of
if
course.
you have something you want to say before then, feel free to finish up.
Nope, we can go into the
So
second.
on the second topic,
Your Honor.
you say that the answer is dictated by the plain text of the statute. I guess why do you say that? What's the plain text of the statute you think answers the valuation question?
I think for both the transfer and recordation tax statutes, the statute explicitly says that the tax is paid at the time the deed is submitted to the mayor for recordation.
And why does that tell you how you value the tax in various settings?
And I think that in combination with the fact that the premise of all of these statutes is that the deeds are submitted for recordation within 30 days of the transfer, which is how the law applies. Once that happens, you're supposed to submit it within 30 days. Plus you have the explicit timing provision about all of this applying at the time the deed is submitted for recordation. I think then when you get to fair market value, that's calculated at
Yeah,
the
so
time.
Here's where I start seeing plain language problems that make it more complicated, at least for me. So in a deed where the consideration is stated on the face of the deed. So let's say that the deed here had $1 million of consideration, which probably might have been nominal considering the value, but assuming that it
Sure.
weren't. The amount of the tax would be the consideration paid at the time of the transfer, even if the recordation is way late. Is that true?
I think that's right, unless it is nominal
Right.
consideration,
So assuming it's
as you
not
said.
nominal, that's.
Yes, I think that's true. But I think
So just, yeah, I mean, which shows you that the statute with respect to valuation, at least in one scenario where non-nominal consideration is on the face of the deed, does not point you to the time of the recordation in determining the amount of the tax. It points you to the time of the transfer.
yes, but I think in the mine run of cases where the deeds are submitted within 30 days of the time of the transfer, the way that the statute is supposed to work is that the consideration is supposed to be a proxy for the fair market value at the time of the recordation, not just at the time of the transfer.
That's 100% fair point, which I think shows mostly that these statutes and the relevant regulations, which we haven't talked about yet, were not drafted contemplating the possibility that there would be a long delay in recordation. So they just didn't assort. But if given the way it is worded, it's clear that if on the face of let's say the value of this property was $100 million in 2002, let's assume that was true. If the position that I think the district is taking and that OTR and the trial court adopted would say that if this deed had been a full consideration deed and it said $100 million, that the tax would be for that amount, even if recordation was in 2022. And so why does it make sense to attribute to the legislature the idea that where you have a nominal consideration deed or a no consideration deed, the amount of the tax will not be the actual value of the property at the time, but instead will be a number to be determined later, depending on the fluctuation of the real estate market up or down. So that if the real estate market had somewhat, not historically, I guess, had gone down, 5 times, that the amount of the tax would be measured against the current value, which would be 20 million instead of 100 million. And if instead it went up, as more typically it has done historically, it would be a lot more. Why is that a sensible view to attribute to the legislature?
Well, because I think what the council is doing is what it does in a lot of tax cases, which is creating a default rule that is knowable in advance, administrable for the agency. And even though there may be some, exceptions in that situation where one party might say, oh, I waited 17 years and I didn't comply with the law and now I owe more money. In most cases, and where people are complying with the law, there's going to be an overlap in the Venn diagram between the value at the time the deed is submitted for recordation and the value at the time of transfer. So I think the answer is just there has to be a default rule. That it is not correct to say that the statute is silent about the timing, because every indication in the statute is that all of this happens at the time the deed is submitted for
So
recordation.
let me ask you about nominal deeds that have consideration is alleged to be nominal.
Mhm.
So let's say in a hypothetical that somebody, I don't know, transferred property in 1900, and the amount of the consideration is on the face of the deed, it's $100, and at the time that would not be nominal. Is your view that if recordation comes up, if the recordation doesn't happen until 2022 or whatever it is, that whether the consideration is nominal is determined not by whether it was nominal at the time of the transaction when it wasn't, but instead whether it's nominal relevant to the value of the property now?
Yeah, it's a tough question, but I think if you look at the regulations, and actually if you look at the tax return form, the form says put in the amount of consideration, and then the form says what is the current assessed value. And so I think the answer is yes. And again, especially with recordation, the service that the district is giving is the recordation of the deed. And so it makes sense to look at the value of the property at the time the deed is submitted for recordation.
That works a little better with recordation than transfer. And I want to talk about the regs with respect to transfer.
Mhm.
As an antecedent question, just a theoretical, conceptual question, when do you think the transfer tax is due? When do you think the taxpayer owes you the transfer tax?
I believe under the statute is at the time oh, sorry, I'm looking at the recordation. At the time the deed is submitted to the mayor for recordation, I believe is 47903A1B.
Well,
that's
when you're supposed to
transfer
pay it,
tax.
but you're
Yes.
also supposed to record it within 30 days.
Right.
And so my question is, do you think they owe you, do you think you were owed a debt 30, because there was no record, there's a duty, you have to pay it when you record it. There's a duty to record within
Right.
30 days. So you could say adding A to B, after 30 days, even if you don't record, you have a duty to pay.
Yeah.
And that you have a debt to the district that is unsatisfied. And I'm asking you if that's the way you conceive of it, or if you don't conceive.
I
of it
see.
that
So
way.
you're sort of asking a question about like, would interest be due at a certain point later or something
Well,
like
that's
that?
a consequence
Yeah,
of the theoretical potential consequence.
I don't know that we have a position on that in this case. I don't want to get too far ahead of it. There is a bankruptcy court decision that said, no, the tax is due at the time it is submitted. Therefore no interest. So just so the court is aware of that, at least one court has said that,
Right.
which I think, as Judge Deal mentioned earlier, I think actually lends more support to the view that the fair market value is at the time of recordation and
I
transfer.
agree it would if that's a correct conclusion.
Yes.
I'm unsure whether it's a correct conclusion or not. And I guess the reason it has more consequences than interest in that if if the right way of conceiving it is that the tax is due within 30 days of recordation, then it is conceptually harder to understand that the amount of that debt fluctuates over time. You would think that instead the debt is set as of then, and if there is a way of compensating the district for undue delay in paying the debt, that would be prejudgment interest or something like that. So it relates to whether the right way of looking at it is to think that the value of the debt is determined as of the time, right around the time of the transfer, or instead at the time of recordation. So let me just ask you about the reg. This is my last question I have about that. This is the transfer tax transfer tax reg 9 DCMR 602.
Yep.
And it says the tax, it begins, but then it picks up and says the tax shall be paid within 30 days and at the same time, the deed evidencing the transfer is submitted for recordation. That's puzzling in that if I mean, you can't, if you're late, you can't have done both those things. But it does seem to say that it seems to be worded as though the tax, it shall be paid within 30 days. It wouldn't be, that's not correct in isolation. If the right view is, no, the tax isn't due or payable until recordation, you have a legal duty to record, but you have no debt until the moment of recordation, in which case then the debt arises. The regulation doesn't seem to be worded that way. It seems to say that the tax shall be paid within 30 days of transfer, which is when the duty to record requires recordation, and you could say creates the debt requiring payment of the tax. So it just seemed to me like the reg is worded in a way that is awkward or inconsistent with the theory that there's no debt at the time of the failure to record within 30 days, and instead the debt arises for in the first instance at the moment of recordation.
I think I see your point, Your Honor. None of this has been briefed by LHL, so I'm not sure I have a very developed response for you, but I would just say, I think we can look again at the language of the statute, which refers to at the time a deed is submitted for recordation. And actually the bankruptcy court that I was talking about with respect to the interest found it notable that the language of the recordation statute and the transfer statute was the same. And we have that same situation here too. So I think even if Your Honor thinks maybe that regulation might, be a strange way of referring to the statute, I think the fact that the council in both the transfer and recordation statutes use the exact same language at the time the deed is submitted for recordation, I think that answers the question of when the fair market value is established. And as we said in our brief, I think OTR is also owed deference on their reasonable interpretation of that statute. And I think unless the court has any other questions on any of those issues, we would ask that you affirm. Thank you.
Thank you, counsel. We are now from counsel for LHO in rebuttal. Your 4 minutes.
Thank you. In honor to your question, Your Honor, if you look at one of the SA8 in the record, the State Corporation Commission finds that the accompanying articles, that was done on February 7th. That was the Thursday, and the no consideration deed of confirmation was also done that same date when the State Corporation Commission confirmed that the LLC was in creation. And the articles of.
I'm sorry, can you say again what you just said? You said that something confirmed that the LLC was
There
quote
was a
in
no
creation.
consideration deed of confirmation under Virginia law because it was going from a general partnership. And it said, whereas the grantor converted from a general partnership to a limited liability pursuant to certain articles of merger filed with the State Corporation Commission of the Commonwealth of Virginia on February 7th as document blah, blah, blah. For purposes of documenting said conversion in the land records, the parties hereafter wish to confirm that title of the subject property is now in LHL Realty BC LLC, a Virginia limited liability, and that for and in consideration the sum of $0. So that was issued, filed with the State Corporation Commission. And then the State Corporation Commission, if you look down, it had that it was filed on a Saturday, which was the Saturday before the 7th, February 2nd. And that was basically filed with the State Corporation Commission, and the certificate was effective February 7th. So Ted Morrison, who was the commissioner of the State Corporation at that time, issued it on the 7th. So the entity was created on the 7th.
And tell me which page are
This
you on now?
SA8, Your Honor.
This is SA8. 9.
And then SA9 is behind it.
And you said one document was dated the 7th and
It was dated, both of them are dated. If you look at it, they're dated the 7th, Your Honor. It's got
no, I thought you said something was dated the 2nd.
the 2nd.
I'm sorry, I thought SA9, the no consideration deed of confirmation is from 2000, that's the 2019 document.
That was what was made to try to comply with the requirement that there be a deed when you wanted to sell the property to a third party, if I recall.
SA 41 is the agreement and was called the plan of merger, but that was entered into on February 4th, 2002 between LHL Realty Company of Virginia General Partnership and LHL Realty DC LLC of Virginia Limited Liability. So they had the agreement in place on the 4th, which was that Monday. And then they filed everything with the Virginia State Corporation Commission to create the LLC, and it was created on the 7th. So this answers the question, was the LLC created before they had the intention of moving the property from the general partnership into the LLC? They did that agreement ahead of time. They then created the LLC at State Corporation Commission on the 7th, which was on that Thursday. And then that's when it took effect. And that's when they also, the no consideration deed of confirmation was filed with the State Corporation Commission on the 7th as well.
I'm sorry, I might be being dense here, but which of those things tells me that the LLC didn't pre-exist?
The LLC they did the agreement where the general partnership agreed to move the property into the LLC was done on February 4th. So that was their intent of moving the property. Then the State Corporation Commission confirmed that the LLC was created. The date of the creation of the LLC in the Commonwealth of Virginia was the 7th.
And what date, what page of the record?
That is
Supplemental appendix
SA 8 is the creation of the state corporation, of the confirmation by the state corporation. An LLC in the Commonwealth is not created, and I will be more than happy to provide additional documentation to the court, either in brief or in information, however the court wants it. Virginia, you don't have anything until
Yeah,
you
but
get
that,
this.
that document doesn't by its terms say the LLC did not exist. It may imply it, I guess, because the first sentence is there's some articles that have been submitted and they comply with the requirements of law. And maybe you could infer that that means that that was being created, that is.
I mean, it actually says the LLC, which continues to exist.
Right.
That-
Later it
that's-
says.
that's
it
not
uses the word
helpful.
It
continues.
says,
But it doesn't expressly say this is we are bringing into existence by this order a legal entity in the Commonwealth of Virginia that did not previously exist. And as Judge Deal points out, the word continues in there is a little ambiguous. It could mean continues to exist after the merger that happens after the beginning of this order, or we recognize the existence of a thing that didn't previously exist, but it just doesn't expressly say that.
Can I ask you something slightly adjacent to this, ma'am? Is it, so, one easy thing that it seems to me that a court could do and could have done at the trial court level or elsewhere is to take official notice of the Virginia records, which may show that February 7th, 2002 date. Is it too little too late now?
well, considering your honor, we filed under protest. There was the third-party sale, which, by the way, when the court was asking about pricing and about fair market value, not to not answer your question, your honor, but in 2002, the value of the property was $94,612, $612,000. In 2019, on the day that they required that they file record in order to be able to do the third-party transaction, that was DC valued it at $203,420, $203,420,950. On June 12th, which is when that third-party event occurred, that they went to record the June 12th one and were told they couldn't because they hadn't filed the 2002. The price that was done on that recordation, the market valuation on that was $162,750,000. So this goes to me again, and that valuation issue, that they required them, they arbitrarily decided it was $203 million and change. And then on June 12th, when they got the fair market value, and they had knowledge of that because that's what they went to file first, was 162 million
I mean,
seven
This,
hundred.
this just sounds like a new argument. I mean, it's one thing to say, the new argument sounds to me like they assessed us on a property value of 200 million. That was arbitrary when in fact the fair market value was more like 162 million.
But Your Honor, we're not arguing the fair market value for the third party transaction. That's not in question. I think it goes to the fact that the District of Columbia arbitrarily and which the court thought is reasonable, went and picked a number out. And I agree with the comment that Your Honor made about when is the deed, when is the value determined? And the value is determined at the time that the deed or transfer document that went from the general partnership to the LLC happened. That's when it happened. That's when the debt.
So you're over
arose.
time. So if you want to wrap up in a
Yes,
sentence.
but I like your argument, Your Honor. That's when the debt arose, is when that happened. And there is nothing in the law that basically gives any guidance as to the time. It was a decision by the OTR. I appreciate the court's time and patience on this matter. And obviously, we ask that the Superior Court's ruling be overturned if the court decides that the transaction, that the exemption was not applicable to the 2002 transaction. We ask that the valuation of the 2002 transaction be honored rather than the arbitrary one selected by the District of Columbia Office of Tax and Revenue. Thank you, Your Honors.
Thank you to Councilor Rose Sides for your briefs and your arguments today, and the case is under submission. I will call now the second case on today's calendar, number 23 CV 720, CASA Ruby Incorporated versus HASSAN NAVEED et al. And before we get started in that argument, I hope that someone from one of the counsel from Appellee will stand at the podium and just let me know how the counsel for Appellees intend to divide up their argument time. So once everybody gets organized, I'm hoping to hear about that.
Our plan is to do 8 minutes and 8 minutes.
So two people are going to argue,
We're splitting, yes.
and who are the two who are going to argue?
Attorney Lewis and myself, Allison Rogers.
And 8 minutes each. Great. Thank you.
Thank you.
And who will speak first? Great. Proceed.
Good morning, Your Honors. May it please the court, Ted Howard for the appellant CASA Ruby Inc. The question presented, we submit, is whether at the threshold pleading stage of a case, pleadings alleging facts that support an inference that a DC nonprofit's former directors engaged in acts or omissions with respect to the nonprofit's governance and oversight amounting to, quote, willful blindness, unquote, or deliberate indifference, quote, unquote, to the nonprofit's continuing viability and well-being, state a claim as to which relief can be granted that would impose monetary liability against the directors under the Nonprofit Corporations Act, DC Code Section 29-406.31 D2, which requires a showing that the directors, quote, intentionally inflicted harm, unquote, upon the nonprofit. We submit that the answer is yes. The Superior Court concluded otherwise, and we ask that its decision be reversed.
I mean, when you say deliberate indifference, the sort of triggers in my mind the notion of recklessness. Recklessness is not a permissible basis on which to find them personally liable under the statute. And so when I read your brief, a lot of it reads to me to be saying, well, gross negligence and recklessness are enough. I take it, is that your position?
No, Your Honor, we ultimately don't disagree with the way that the Superior Court formulated the standard and concluded that actual knowledge was an element under Section 29-406.31 D2.
So they need to know that Corrado is pilfering the organization, right?
Well, we ultimately submit, Your Honor, that our allegations are sufficient to support a finding that they did. And there's a laundry list of things that we've alleged in the briefs that they did or failed to do over a period of time, including failure to hold meetings as required by the bylaws, failure to monitor the records and books of the nonprofit, et cetera. During which time Ms. Corrado was engaging in a series of acts of self-dealing.
But you could definitely fail at those things and not know what's going on, right?
That's true, and
So
I
what's
think that's
the thing? So I mean, just what added? And on the facts here, it's plausible to think they did know.
right.
And how does that just not reduce into a recklessness standard?
We think, Your Honor, and submit and have briefed the point that at the end of this sequence of acts or omissions, that in 2020 and in 2021, after this significant period of passage of time, the board met in order to consider transitioning leadership of CASA Ruby. At
We
that
have
point-
no information or allegation about what prompted that or whether it related to anything that would give rise to suspicion of harm, of the kind of harm that would be cognizable here to CASA Ruby, or do we?
Well, Your Honor, I think that's the crux of the case, whether under the pleading standard for 12b-6, we have to be able to spell it out in detail when we haven't had any discovery.
Understood, but I just, that's an argument that you don't need to have. What I was asking whether you do have, but just to be concrete about the factual question, is it right that there is nothing in the complaint or its incorporation of the third report of the receiver that says in any specific terms the nature of the reasons for why the board met then to consider the possibility of a transition of leadership? We just
That's
don't know.
correct.
That's just a
We don't
mystery. We
know.
don't know why.
We don't know why they met. We
Can I
don't
ask you,
know.
I mean, I take your, I mean, your line of thinking at a high level abstraction is part, this is a plausibility standard, so the threshold is not that demanding. And if the board was just doing, the members of the board were doing, or more to the point, not doing so many fundamental things that any board would do. You think that a reasonable fact, even by that alone, it seems like, as to some of the board members, you think a reasonable fact finder, and then as it happens, there'll be proof that lots of bad things were happening at the organization at that time.
That's correct.
And your line of thinking at its most generalized is you think it's plausible enough that anybody would infer they had to have actually known that harm to the organization was happening, because how else or why else are they not doing any of the things they're supposed to be doing?
And then
is
all of a
is that the
sudden they
line of
spring
thinking, or-
into action.
Well,
sort of.
into resignation action, I guess, but is that, I mean, is that the line of thinking? I guess it's just, I mean, can you point us to cases or anything that would shed light on whether that is too speculative and it's just lots of people don't do what they're supposed to do for lots of reasons? You know, I'm sure there are lots of boards and entities that have corporate formalities that are supposed to be being honored and aren't, and, you know, small corporations that are, you know, not well lawyered and don't have lots of resources. I'm sure that, you know, all sorts of meetings that they're supposed to have aren't happening. That's just, that's common sense to the extent I claim to have any of it. So it leads me to be unsure that if really all you had, and I think you may have some more, but if really all you had was just this complete fundamental abdication of the board members of everything a board should be doing, Therefore, it's plausible for a fact finder to infer that they must have known that bad things were happening in the corporation. That right now, that seems a little speculative to me, or a fair bit speculative to me. So
Your Honor, I understand. And I think that the context is important because as articulated by Judge Dason in her decision below, first of all, she rejected the proposition as a matter of law, it seems, that anything amounting to willful blindness could ever serve as the surrogate for actual knowledge.
can I, and
and-
let me just interrupt you there, because I want to get back to what you just said. Seems to me a little bit in tension with something that I understood you to say to Judge Deal. So I want to make sure I understand your legal position. Willful blindness can perform two analytical functions that I think are different. And I'm just want to make sure I understand which one you are thinking it should have played, if either. One of them is to say, if you can show that someone did willful blindness kind of activity, they took steps to avoid specifically being informed about a thing, that can be part of, maybe sometimes by itself enough to infer actual knowledge in the subjective awareness sense. That's sort of as, willful knowledge as a predicate to inferring, willful blindness as a predicate to inferring subjective actual knowledge.
Yes, Your Honor.
I think it's well understood that it is at least willful blindness type activity can contribute to such an inference, whether by itself in any given circumstances it would be enough, its own topic.
I think the case law reflects that, Your Honor.
Right. So that part I understand, but when you use the word surrogate, I got a little unsure about whether you meant to try to rely on willful blindness in a different way. Sometimes willful blindness is like a statutory interpretation concept, not a predicate for an inference, but the statute says knowledge, but we will interpret that to mean either subjective actual knowledge or willful blindness. If that's proven, we're going to treat that as covered by the word knowledge in the statute. That's not as a predicate for a further inference. It's just the statute reaches willful blindness as a form of knowledge that is sufficient. Are you arguing that this statute should have been interpreted by the trial court to allow for willful blindness to play that second role, which is subjective knowledge is not actually required to be proven? Willful blindness itself is like enough of an end zone to be within the definition of knowledge, which of course isn't in the statutory language anyway. Knowledge is kind of a gloss on what intent means.
No, Your Honor,
are
we are embracing the first of those interpretations, not the second.
Can you help me out with your complaint and just point me to where the allegation is included that they knew Corrado is pilfering funds from the organization?
It's not there, Your Honor.
Mm-hmm.
What we are arguing is that this is a board that by its conduct reflected a total disinclination to fulfill its obligations as directors to oversee the management, the supervision, the functioning of this nonprofit. And that during this period of time, all sorts of bad things were happening, and they were doing nothing. And then all of a sudden in 2020 and 2021, they decide to meet for purposes of considering transitioning the leadership of the organization. We don't think that it's a stretch in terms of inferences to believe at that point that somehow or another they knew that something bad was happening and that some kind of action might be required. And even then, they didn't act to replace Ms. Corrado. Let
me just kind of spell out what I think are two very different theories and where I get a little tripped up in this case. As you've just described it, that sounds very much like gross negligence. They should be doing stuff. They're not doing something. There's no good reason for any of that. It's a big dereliction of duty on their part. And I think that's probably not going to satisfy the statutory standard for holding somebody personally liable. A different way of framing it, which I'm not sure that you framed it this way in the trial court proceedings, but maybe you're framing it this way now, and maybe it's a fair way to read it, is, look, you look at all of that, and these guys knew. They knew what was going on. There's just no other explanation for it. That's a fair inference. Caveat whether or not that is, I'm not so sure, but there's just not another explanation, and we deserve to get to discovery on that because the only people that are going to know is them. They had closed door meetings. We should be able to depose them. But we think there's enough smoke here for it to be non-speculative that there's fire. They must be in cahoots with her, or at the very least, sort of accepting of her malfeasance despite knowing about it. Do you think you made that second version of the argument to the trial court? Because they're not so far apart. But one strikes me as a gross negligence argument that the trial court was shooting down. And the other one is sort of all of this gets us past plausibility on knowledge, and I just don't see the knowledge allegation. So we should have gotten to discovery. And that's a different flavor of argument, and it strikes me as maybe an important difference between the two ways of framing it.
Your Honor, we believe that when the amended complaint filed by the district and the receiver's third interim report and our supplemental response to the motions to dismiss as requested by Judge Dason are considered together, that we made out the second version of what you just described. And I will try to.
You're also, if you have something you want to point me to in rebuttal, you can, address the arguments you want to address now.
Yeah,
But
I think it's pretty clear that neither the district's original complaint nor your third-party complaint expressly alleged that any of the directors knew what was going on.
I concede that.
And it seems pretty clear that the original complaint, third-party complaint that was filed, wasn't aware that that was a requirement. It tried to address other statutory requirements, but just didn't address that one. So it seems like that was an oversight in the complaint. Now, the supplemental response, which is at the appendix starting at 67, my vague recollection is that it did at least adequately get across the idea that you were alleging subjective knowledge was plausibly inferable from the information you were alleging.
Yes, sir.
That's my recollection, but it'd probably be helpful if you could point us to particular pages where you think that's done, and maybe you could do that in rebuttal. But there's sort of two related points. One is a procedural point, which is if the complaint fails to allege a thing that is required, is that just a defect in the complaint, even if you can extract from the factual information in the complaint an adequate showing to survive a motion to dismiss? The trial court didn't go off on that ground. I'm not sure that's been pressed very clearly. So I thought it had kind of resolved into a question of whether the factual material in the complaint, which incorporate in your third-party complaint, which incorporates the district's complaint and the third report of the receiver, makes out an adequate basis for a plausible inference of subjective knowledge by the board members.
Your Honor, I think under the generous pleading rules, that what we alleged in the third-party complaint encompassing those other items, the amended complaint of the district and the receiver's interim report, I think we got there.
And I guess, again, the gist of it seems to be the board wasn't doing anything it should have done for a long time. There comes a time when, for reasons we don't yet know, they meet in 2021 for the first time in a long time, and they seem to be concerned about whether they should replace the executive director. They, for reasons we don't know, take no action. Some of them resign, although maybe they did or didn't resign because their social media information seems to say they didn't resign. So there's some uncertainty about whether they did or didn't resign. At some point, there's also somewhat opaque reference to the idea that some employees had asked board members for help of an unspecified kind. So there are these yellow flags or things that are arising. there's evidence that what was happening was there was, plundering of the organization. And so far, no evidence that there was anything else that anybody was concerned about. And then, they resigned without doing anything. And the inference is plausibly, they must have known that things were happening, and I don't know, there would have to be exactly who was plundering what. Maybe it's more abstract. They must have known, well, plausibly, it could be inferred that they knew that what was happening at the organization was doing harm to the organization of a kind that would be covered by the statute, and they intentionally did nothing, inferably knowing that. That's am I missing, except for that there's a little bit more with respect to board member Zoltik. Because if I understand, but for the rest of them, that's what there is. Is that a fair description of what there
That
is?
is exactly what there is, Your Honor.
And there's just a question of whether that's enough or not enough. And it seems to me it's not obvious that's enough. It seems like that's on the weak side. With respect to board member Zoltik, there's a little bit more. There's evidence, I gather, that in February, she requested financial information. There's no indication she got it. And she then resigns without taking any further action. Is that an accurate description of what additional there is about Ms. Zoltik, or am I missing something?
I believe it is, Your Honor, but I want to be careful because this factual support for those propositions is basically encompassed by the declaration that Ms. Zoltik filed.
That information appears only in the declarations that got struck.
In support
that were
of her
stricken.
motion to dismiss, which Judge Dason said she was not going to consider, because if she did, she would need to convert the motions to dismiss
I
into a
see.
motion for summary judgment. At which point we would have been
That's-
entitled to discover.
I see. So, and you haven't contested that ruling. So you're agreeing, I gather, that some of what I just said about factual information in the record that relates to Ms. Zoltik is not proper, was treated as the trial court is not properly in front of it for purposes of the motion in question in a ruling that you haven't contested. Is that accurate?
Except that,
Because
Your Honor, I
think
believe
some of
that
was in the
I believe in the
report of
third
the
interim
receiver,
report from the receiver,
which was incorporated into the complaint.
which was incorporated in the complaint. He did allege that she resigned without taking action. I don't believe he necessarily pointed to specificity to any suggestion that she affirmatively requested
This is
information that she didn't
Appendix
get.
14. What I was just saying about Ms. Zoltik, about asking for documents at a meeting, asking for audit financials and the like, on February 6th, and then 17 days later, she resigns without taking any further action. I thought that was in the third report, and it's in Appendix 14. So I don't think that you're quite right that there was additional information from a number of the defendants in the declarations that were submitted with their motions, and the trial court said, I'm going to treat this as a motion to dismiss. I'm not going to treat it as summary judgment. I'm not going to consider any of those declarations. I'm going to strike them. But I don't think that affects what I was just saying about Ms. Zoltik.
That's correct, Your Honor. I stand corrected. My apologies. In any event, Your Honor, I note that I violated the first rule by failing to reserve any rebuttal time. If I may have 2 minutes.
We will give you a couple
after,
minutes in
we
use
hear from the appellees, I'd appreciate it. Thank you.
If my colleagues have any further questions. All right. Thank you,
Thank
counsel.
you.
We'll hear from you in rebuttal. I believe counsel are dividing their 15 minutes approximately in 8 minutes each. So.
May it please the court? My name is Deanna Maria Lewis, and I represent the appellee, Meredith Zoltik, in this matter. This appeal arises from the DC Superior Court's well-reasoned decision granting the appellee Zoltik's motion to dismiss, which was joined in by her colleagues, other board members here today. The court correctly held both that there were no facts alleged to support a conclusion that individual board members, including Ms. Zoltik, acted with actual knowledge or that their inaction as a board would cause harm to the organization. And also that there was no support for appellant's attempts to satisfy the intent requirement of the Nonprofit Corporation Act, also abbreviated as NCA, with allegations of a willful blindness standard, which appellant is ultimately using as a basis for its argument to seek monetary damages from the board of directors. Panel, I want to address a few points that were raised during the appellant's opening remarks. First, as Judge McLeese pointed out, in the amended complaint, specifically paragraph 71, that is actually where it does note, as I think was clarified, which appellant counsel conceded, that Meredith Zoltik did in fact request financial information. She sought information on behalf of the board, but the other issue is that there was no quorum to do any business. And subsequently, she had to resign, which she did.
Well, what you just said right now about there was no quorum and the like, is that something that's in the record or that is before us?
It is not in the amended complaint, but that was proffered, but it was not a part of the current complaint because the declaration was.
So
scrapped.
that's not,
So we-
shouldn't be in front of us for current purposes.
So we will withdraw that remark, Your Honor. However, everything else is absolutely
And
relevant.
why does that help your client? It seems like at least arguably it hurts your client. I mean, the picture as to your client that your opponent would paint is she, along with the other members of the board, were, I don't mean to be, not doing any of the things that they should be doing, not doing any supervision or anything. There comes a time when there's the general information about they have a meeting and they seem to have concerns of possibly to replace Ms. Corrado. There's this reference to employees wanting help that's somewhat abstract. But then as to your client in February, your client obviously has some concerns that bad things are happening, financial in character, or at least inferentially, let's say, and asks for a bunch of documents. As far as the record reveals, doesn't get them, resigns without notifying anybody. Why doesn't that allow a reasonable fact finder at a plausibility standard to say, she probably knew that there were bad things going on in this organization, and instead of acting like a fiduciary and taking reasonable steps to stop it. Now, maybe she didn't have a quorum and couldn't take a business, have the board cause anything to happen, but she could at a minimum notify the authorities that terrible things are happening to the organization. Instead, she does nothing and leaves. Why isn't that an omission that could plausibly be inferred was accompanied by actual knowledge by your client that that omission was going to cause harm of the kind prohibited by the statute to CASA?
Well, Your Honor, there was actually an interim director that was attempted to be put in place. And as a result of the interim director stepping down, Ms. Zoltik subsequently stepped down. So there was no knowledge by Ms. Zoltik that Ms. Corrado did not ever transfer over any of the bank accounts. Appellant seems to make a big deal out of the fact that they were meeting in 20 and 21, essentially still permitting Ms. Corrado to have access to the bank accounts.
Again, I don't want to get into factual allegations that are not in the complaint and the documents it incorporates, and in particular things that are either outside anything or that are in the declarations that were stricken. But if leaving out that material, it sounds like one of your points is there's some information in the record that might have allowed a fact finder to think maybe Ms. Zoltik wasn't just leaving a ship that was sinking, that she knew it was sinking, and that instead of taking reasonable steps for her fiduciary responsibilities, she just jumped ship, to continue the metaphor. Maybe one could view that as instead she may have believed that there were steps being taken that would solve the problem.
That's
And that's possibly true, although again, on a plausibility standard, I'm not sure that a reasonable fact finder would be required to think that it was so clear that she thought reasonable steps were being taken that, it couldn't be inferred that instead she had actual knowledge that harm would ensue. But I get that possible thought. I just am not sure how it works under a dismissal plausibility standard.
Well, so Your Honor, we would kind of join in with the lower court's decision and the dicta of the opinion that the facts as alleged, including in the amended complaint, which by the way was not amended because the motion to dismiss was dismissed without prejudice. And so there were opportunities for any of these additional allegations regarding the plausibility or the possibility of plausibility or other factual allegations that may have made the appellant's arguments more probable than speculative, which absolutely they are, we agree and join in with the court's decision that there are no facts alleged that a reasonable inference that the board members, including Ms. Zoltik, had a subjective belief that there was a high probability of Ruby Corrado's alleged malfeasance, nor that they took deliberate steps to avoid the learning of her malfeasance. So to go back to your question, Your Honor, I mean, sure, you could read that, but it's not just about did she have an inkling of or a scintilla of information or probability. It's about having a high probability that there was in fact alleged malfeasance and that there was a subjective belief. No facts present in the record and the amended complaint get to that point. And Your Honor, it's also
I
very.
think just to kind of clarify one topic that we discussed earlier, at page 71 of the complaint, there actually is the allegation seemingly coupled with Ms. Zoltik's inability to get these financial documents that the board couldn't determine whether or not they had a quorum. I think that was the comment that you said and then kind of
Yes.
rescinded. It's in the complaint, suggesting this was not, here's an easy thing I can do to force her to hand over the documents, and I'm not going to do it. The allegations are, well, the reason you couldn't have done anything is because you didn't know if you had a quorum or not, and so you wouldn't have been able to do it anyway. I mean, that seems to undercut the notion that they took deliberate action that they knew would have led to harm to the organization.
So correct, but what we're saying is that there were no subjective beliefs. There's nothing in the record to support that there were in fact subjective beliefs, that there was a high probability.
You know, it's
There's
a very
not-
tough thing to, I mean, it's subjective beliefs of other individuals is a very tough thing to plead beyond sort of blanket assertions, right? There's so much, here's really all you can do. And, you know, maybe Casa Ruby didn't even do this much. But look at all the malfeasance of all these board members. There's not another plausible explanation other than they didn't want to uncover what they knew to be some gross malfeasance of Ms. Corrado. And, you know, then if you're talking about summary judgment, if they don't have anything more than that, then it's definitely out. But when you're just talking about pleading, how much can you say? You haven't had a chance to depose them yet. I mean, you don't need a smoking gun, that's for sure. So why isn't it enough to say, look, you know, we don't know what's in their heads, but we should get to discovery because this is all bad enough that there is a plausible inference that's what's going on here is they are ignoring, you know, they know what's going on and they don't want to find out.
A couple of things, Your Honor. I see that I'm running short on time, but I would like to address your question with a few points. So specifically, there was no, as I mentioned earlier, there was no amendment to the complaint that there was even objective knowledge. So there wasn't plausible knowledge amended in the complaint. There wasn't objective knowledge. And also, I think it's extremely important to understand that the NCA is clear that only under specific circumstances.
When you say objective knowledge, you mean that they should have known?
Correct. There's nothing in the amended complaint saying that they actually knew, they subjectively knew, or they objectively knew. And so under the NCA, it is explicit that in terms of board director liability, it's limited and clearly articulated, particularly for limited circumstances for monetary damages, that there has to be a clear showing of intentional infliction of harm, such that individual board members of a nonprofit can then be held liable. It boils down to the intent requirement. In the mens rea here.
Can I ask, were you quoting for something when you said clear showing? Is that, or is that your,
This is
position?
section 29-406.31D2 of the statute, Your Honor.
I'm just asking what the words clear showing and what you said. Is that something that you think is established somewhere that there's some heightened obligation, or does it just have to be a showing? There's no heightened proof requirement.
So those, Your Honor, and I'm just going to double check because I do have the statute here and I want to make sure that those are not my words. But specifically, if we look at D2, here it says intentional infliction of harm. So I think it's my words that it's a clear showing. So it has to be a showing of an intentional infliction of harm pursuant to D2.
Could you, just a legal framework question. I think this is true from your briefs, but I just want to confirm whether it's true. The trial court interpreted D2's language about intentional infliction of harm to be met if there was an intentional action or omission by a director that the director knew would cause the requisite harm. That was relying on a DC District Court opinion, Bronner, and also, which in turn relied on the model statute and commentaries to the model statute. I take it that you agree, you don't dispute that is the correct legal framework.
Correct, Your Honor. And it is
Just wanna make sure.
our position that the appellant is trying to detour from that correct legal framework that we think is explicit. We think it's supported by the DC Council's legislative intent. We think it's clear in the law, and it's also supported by the legislative history here. And related to the Model Business Nonprofit Corporation Act in comparison to what we have here in the District of Columbia, if there were requirements to have those specific languages and those specific provisions and intentionality and mens rea, it would absolutely be there. So now what the appellant is attempting to do is extend what is clear on its face. And it's not just because it's a plain reading of the law, as the appellant has argued in its brief. It's clear on its face. The judge in the Superior Court did a lower court assessment related to the legislative intent and history of what the DC Council intended. There was analogous comparison.
Counsel,
between the-
you're over your time, so if you want to wrap up,
Yes,
feel free to
I will.
wrap
I
up. in a
sure will.
sentence.
Let me ask
And
one
then also a
question
question.
too. I'm getting somewhat confused. You seem to be holding them potentially to a heightened pleading standard here. And I wonder if in your view, normally in most scenarios, we view direct and circumstantial evidence as roughly equivalent. But it seems like from what you're telling me, and please correct me if I'm wrong, that you're saying unless we've got some sort of direct evidence of intentionality, there is nothing that they can really plead here that we should give them the benefit of the doubt on to let them get to discovery on this knowledge piece of the intent.
So Your Honor, I'm not actually holding them to a heightened standard. And I think it's also important to note that our clients were deposed in this case. There was limited discovery that was taken. So to sit up here and essentially purport as though there was no discovery, we provided written discovery and depositions. Multiple board members, including appellant's own clients, were
But again,
deposed as well.
for current
We-
purposes, that's not in front of us, right?
We do understand that, but I do think it's important to have the record clear. But Judge Howard, to get to your point, in terms of the pleading standard, and it goes back to what I said earlier, there was nothing in the amended complaint, the original complaint, that makes any argument here or allegations that there was any intentionality, that there was any knowledge or notice, subjective, objective, and this is all about the plausibility standard, which we join in the court's opinion because the court actually acknowledged this. The court said, the lower court said that there was recklessness or potential reckless disregard or negligence. And so as a result, we agree with the court's opinion and the analysis there too. And so accordingly, thank you for your time. I see that my time has expired, and we would ask that you all affirm the DC Court's opinion.
Thank you, counsel. Ms. Rogers?
Thank you, and may it please the court. I would just ask if necessary for a couple of extra minutes since counsel gets a couple of minutes, if it's necessary. Your Honors.
You probably
this
inferred
case-
that we don't
Yeah.
run our time limits like a train schedule, so I'm sure you'll have ample time.
I appreciate that. Thank you. I want to address the specific questions, but first, I just want to take us into a different headspace about what's in the pleadings than's been discussed today. This case set forth in the pleadings, which I will quote from, arises from the collapse of a nonprofit. There's no question. But it's also, we're here today because of a failed attempt to shift blame onto former volunteer board members. I represent Mr. Hassan Naveed, and he was a public servant. And in the pleadings, they aver over and over that, like one of several former board members represented here today, they served Casa Ruby as volunteers. They did make actions to advocate for oversight. I will be citing to the pleadings on that. And ultimately, they resigned when they could do no more. He's here today, not because he did anything wrong, but because he was actually one of the last honest actors left at the organization from the pleadings. You've just heard an interpretation of DC law that would hold every director personally liable for monetary penalties. for intentional acts of an executive director, Ruby Corrado, even whereas here the pleadings do not allege that they had knowledge, that they should have, that they could have, that they had authorization, or that they personally benefited. In fact, the pleadings say that had they met in years 2014 to 2020, when $9 million was being raised in the pleadings, it says by Ruby Corrado, had they met, they may have discovered what was going on. This is a person who was walked down the aisle by the mayor. These are volunteer board members. You're right. Corporate formalities
So
are
Let
important.
me ask you then.
Yes.
I get, these are volunteer board members. They are doing this out of the kindness of their hearts. They're interested in how it may burnish their career, et cetera, their commitment to a cause. What remedy, in your view, if we're going to make such a big deal out of that point, is available if directors can't be held financially accountable for activity that took place under their watch, seemingly under their noses, that, not saying that I agree with the point, but that is being alleged, there's a lot they could have done and should have done as fiduciaries.
I understand your point, Your Honor. I'm not advocating they shouldn't be held liable. I'm advocating it's not alleged that they would have known, could have known, or should have known. And this was dismissed without prejudice. If counsel felt that they could have known, should have known, and that he wasn't just going on a fishing expedition, he merely needed to amend the pleading below and say, they should have known or they could have known. It doesn't, it says may,
Yeah,
maybe.
They're two
Yeah.
related topics. We touched on this a little bit. I just want to make
Sure.
sure if you're making an independent procedural point. So one question is, leave aside what is explicitly alleged in the complaint. Instead, I'm just saying that this is like a sufficiency of the evidence type inquiry,
Sure.
and there's a pleading type inquiry. So just for a moment, focusing on the sufficiency, you could say, leave aside what the complaint did or didn't allege in terms of legal theories. Look at the facts that are alleged in the complaint, look at the legal standard in D2 and figure out whether a plausible case has been made that is met. That's a substantive question, really, not so much about how the complaint is legally worded. And that's most of what that's what the trial court went off on, is I think primarily, you could remind me if I'm incorrect.
No,
on that.
I agree.
But there's a separate
Certainly.
procedural point, which could
Yeah.
be, imagine that there were all sorts of facts that supported an inference that the statutory standard was met. If the complaint doesn't allege it, the complaint is legally defective. It doesn't have in it the legal theories that it needs to have. Are you making an argument that even if there was enough factual information to meet the standard, we should, dismiss because the complaint was defective and not focusing on that?
Absolutely.
You want-
Let me make every point, okay? So first of all, and I'll be brief because I only have 3.5 minutes, okay? First of all, subsection D2 provides clear intent to harm. It's not been alleged that these board members wanted to harm the organization at any time. A separate
But
section.
do you also agree, as your colleague on your side of the podium did, that intent to harm is enough, knowledge of harm, intentional acts or omissions with knowledge to harm is enough? As the trial court found?
Your Honor, it has to be, because a separate subsection where counsel could seek non-monetary penalties, and that's subsection A2D.
No, it doesn't have to be. You could say it needs to be willful, that you need to purposely cause the harm, but you're not pushing that argument. You're fighting against a
I'm
lesser
saying under the
standard.
structure, I'm saying under the structure of the statute, another subsection allows for that kind of inquiry, this idea that a sustained failure to devote attention.
I don't think you're
looking-
listening to the questions.
Yeah, my question
Yeah,
was
okay.
pointed in the other directions. My question is,
Yeah.
you are not arguing that actual knowledge of harm, intentional acts and omissions taken with actual knowledge of harm is insufficient. And in fact, there has to be intent to harm to the extent that runs beyond intent or intentional actions or omissions known to harm.
Look, in
Is that
Bronner.
right? Because you're accepting Bronner.
Yes, Your Honor, what I'm alleging.
That's all I was asking.
Yeah, what I'm alleging is that there does in the pleadings have to be an intent to harm the organization. Bronner was a case which observed board members in the pleadings, those board members alleged that they didn't care if the resolution they passed would tear the court apart. And the Model Nonprofit Corporation Act makes clear that for monetary, not non-monetary, for monetary relief, there should be alleged an intent to harm the organization. That's not here. And I'm also obviously making this.
I think the questions that we're asking, I think we have the answer. But
Okay.
the questions are, there is a more exacting view of intent than even the one you are willing to defend. And that view of intent is that somebody needs to want to bring about that result. It's a purposefulness. You are
Right.
not disputing. The trial court doesn't buy that. The trial court says intention to act with knowledge of harm is enough. You don't need willfulness. And you are also here
I'm defending
conceding
the
that you
trial
don't need
court.
willfulness.
I'm
Okay?
defending the trial court
Got it.
position. And if I may, you know, I just want to read from the pleadings here because a lot has been said that's inaccurate. Here's what's alleged. Paragraph 6 cross-claim, by neglecting their duty to provide oversight. Paragraph 9, the board failed to hold regular meetings. Paragraph 14, they breached their fiduciary duties by neglecting to provide oversight. Amended complaint, paragraph 70, the board met in 2020 and 2021 to discuss the status of Casa Ruby's programs, to discuss transitioning to new leadership by appointing an interim executive director. On February 6th, Zotlik asked Corrado to provide certain documents, but she never received this essential information. Paragraph 72, the board had no access to audits. So the pleadings
I
even
think-
state that
I
they
think their
met
point-
regularly.
I think part of their point is people can neglect to take actions in a way that will give rise to a plausible inference that they know what's going on. So let me just give you an example. Let's say the third day of every month, Miss Corrado struts into the office, goes into a safe and takes, $50,000 out of it. And it just so happens, the third day of every month, a board member neglects to lock the door, neglects to lock the safe, and says, we're not going to check the amounts of the safe on the fourth day of the month. We're not going to do any of that. So when you say, well, the complaint says neglect, 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 I mean, that's fine, but sometimes some series of neglect can give rise to an inference of knowledge. Their argument is, yeah, we say they're neglecting these things, but the only plausible explanation or a plausible explanation is that they know what's going on. I get your answer is, no, that's not a plausible inference.
No, my answer is
but
that's
saying-
not what, that's
saying
not this
neglect a lot
case.
Doesn't,
But-
sure.
That's not, no, my clients are here. I'm trying to make a bigger point if I can, because we did ask for attorney's fees in this case. I understand that opposing counsel is here because he thinks this is an issue of first impression and that the case you are discussing is a very interesting case. And this is a very interesting matter to take up. That's not this case. That is not pled here. Out of a sense of duty of my clients, if the court will entertain it, I want to touch that point, which is that, this doesn't raise a good faith question of first impression. It's exciting point, but I'm trying to drive home that this is not the case to make new law on this issue. The statute's very clear. The trial court applied it correctly. The appeal doesn't engage with the statute's actual text, either in implying some kind of intent at all, let alone an intent to do harm. Let alone even saying, oh, well, you can gather from the facts it's plausible that they probably knew. That's not in these pleadings. It's not here. Because the clients didn't know what was going on. And I raise this because I have some concern that there are signs this appeal is, in fact, a witch hunt and retaliatory, okay? The receivers run to the Washington Post, Washington Blade, the receiver's own website provides quotes about the board. The quotes associate the individual board members with Corrado's wrongdoing. And my client has bit his tongue and I have bit my tongue. And even when we won dismissal below, which the trial court sent the case out, my client made the principal decision not to file within 14 days for attorney's fees for the frivolous cross-claim. He did so because he didn't want to drain the organization from further resources.
So
But
then why is that an issue for us?
because, Your Honor, I'm about to state that the receiver's tactics here became clear to go outside of the pleadings and paint this picture that the clients were do nothing board members. The wool was pulled over their eyes just like everyone else. The District of Columbia has not gone after the board members. And when this appeal was filed, I emailed opposing counsel in light of that, asking it to reconsider whether to even bother filing the appeal. Discovery's closed. There's no there. This is not the case where counsel can plausibly argue, oh, they knew what was going on. They didn't know what was going on. And this appeal is draining the organization of reasons. And
I have a procedural question for you about something you said.
Yes.
I had understood that at least some of the board defendants did request some kind of fees or costs in the trial court. Am I right in believing that's true, or am I?
We asked for attorney's fees. The case was granted. The procedure requires that we file a motion to get those attorney's fees. My client made the principled decision not to file that motion in order not to suck the rest of the resources from the organization. And if I can just say this one thing.
Let me just make sure.
Yeah.
Before you.
Yes,
go on to
sir.
other topics, I want to make sure I understand. the
Because I
procedural
haven't
posture of
asked.
it.
Yeah.
Yeah. So you're saying that at some point in the trial court, some of the defendants before the trial court ruled indicated that they had an interest in recovering future
pleadings-
costs.
Our pleadings throughout asked for
Right.
attorney's fees and costs.
And then
Yes.
after the trial court's ruling, the trial court didn't address those references in its order.
Procedurally, we'd have to file Rule 54. Yeah.
And that was not done. And so, but nonetheless, by as far as you know, any of the defendants.
Correct.
Filing a post-judgment request for fees.
Correct. Yes.
For reasons that you've identified. But now you're saying that given that the appeal has been pursued, you are making a request of this court that relates to costs, which would be to do what exactly?
Okay, I know that it's an extraordinary thing to raise, but I'm here and I feel it's necessary because the statute is clear and this is not a case to paint, directors as looking the other way. These are good people. And so I raised with the receiver, given discovery, I'm going to answer it, given the discovery, given the depositions being done, I asked him to reconsider whether this appeal was just a drain on organizational resources. And his response was to change the name of this case to list my client first.
Yeah.
It was
And
never
the
NAVEED
question that you
before.
said you were gonna- the question you said you were going to answer was, my question is, what is it that you want us to do exactly? What are you asking us to do relative to costs?
Well, in a Fifth Circuit case, the court cautioned against fee-driven litigation where the benefit accrues more to counsel than to the estate. And in Flores, this court upheld a Rule 38 sanction where the claim was clearly frivolous. This is not a closed case. The appeal fails to really engage with the relevant statutory text. It relies on inopposite law. It never alleges any individual knowledge, benefit, intent to harm that they should have, could have known. It needlessly targets well-intentioned volunteers of modest means. So respectfully, I would ask the court to affirm the dismissal of the cross-claim on the reasoning of the lower court. And I would further ask the court at least to consider either awarding Mr. NAVEED's attorney's fees under its inherent authority, sua sponte ordering appellant to show cause as to why they should not be responsible for the cost of defending this appeal, or in the alternative under Rule 38. My client and the board members should not bear the cost of litigation the statute was designed to prevent, particularly when the government has declined to pursue him and the allegations do not come close to meeting willful blindness, gross negligence, any of the standards that they propose that you adopt from other jurisdictions. It doesn't come close to pleading anything. It doesn't imply, even though counsel had the opportunity to amend and imply that they probably knew something. My client served his community, this community, without compensation. He asked questions. That's in the pleadings. They tried to do the right thing. When they were stonewalled, they stepped down. And now the very individuals profiting from this non-profit corporation collapse want him to pay their bills. That's not what the law says. That's not what the facts support, and that's not what justice looks like. I appreciate the extra time to make that point. The board feels strongly on this issue. Thank you.
Counsel, we'll hear now from Mr. Howard in rebuttal. I think we'll give you a couple minutes.
Your Honor, I'll try to be brief, and I appreciate the extra time. Your Honor, we're in this case as counsel for CASA Ruby Inc. Because Judge Dason felt that notwithstanding the fact that the entity was essentially defunct, that its legal interests needed to be represented separate and apart from the role that the receiver played in administering and trying to figure out how to resolve the business of CASA Ruby. And we're in it pro bono. And the reason why we have pursued these claims is we believe that as pro bono counsel, it was our responsibility to evaluate the facts as we saw them and understood them, and to determine whether or not the board members who were basically asleep at the switch for any liability. We think we have made a responsible argument with respect to the interpretation of the law. We have offered authority in support of our arguments under the standard as articulated by the trial court. We have not done so in any bad faith. We have asked for a reasonable interpretation on an issue that is a first impression. And the idea that we would be subject to attorney's fees for making this reasonable argument has no basis whatsoever in the law. We have, and I think your honors understand this, so I won't belabor the point. We believe that there is a basis for a reasonable inference on in light of the sequence of events under which a court could find that at least at the 12B6 stage, there are grounds upon which it could be inferred somewhere along the line of this sequence of events that the board had reason to know that Ms. Corrado was engaged in malfeasance.
Reason to know is, I think you would concede not the standard.
Well, that they knew enough by 2020-21 to convene board meetings after years of doing nothing for the purpose of considering changing the leadership of the organization, that is enough to infer that they knew something was going on with regard to Ms. Corrado's and her
Well, and
mistreatment.
something was going on also, pretty
And-
vague. I
Well,
mean, harm, and harm is not a defined term in the statute, but I think it's relatively clear, I think, that they would have to know more than just, wow, things aren't going well. They would have to know that if they didn't take whatever acts you think they omitted taking, which the main one you focus on seems to be in alerting the authorities, that the kind of harm contemplated by the statute, which at least here was plundering the organization. I'm not sure what all kinds of harms would be enough, but again, I don't think reason to know is the right formulation, and I don't think that they knew something was going on would be sufficient either. It would have to be something that was going on that constituted harm to CASA Ruby of a kind contemplated by the statute.
Your Honor,
You agree? I assume you'd agree with those two things.
we don't know why they met in 2020 and 2021 after doing nothing for years. We don't know who was there. We don't know what was said. We don't know any of that.
Right.
We couldn't.
And right, and the question is whether that helps you or hurts you. And I understand your point that you might need discovery to find out some of those things, but you do without discovery, at least discovery that this court can consider at this juncture.
Your Honor, obviously,
you have to get to a plausibility
I
standard. So,
understand
no,
that.
expressing all the
12B6
things you don't know is a double-edged sword because you need to have known enough to allege in the complaint something that meets a plausibility standard.
12B6 motions are granted all the time and parties don't get discovery that they feel like they're entitled to. I get that. As Judge Deal pointed out, when subjective knowledge is involved and the holders of that subjective knowledge have not been the subject of inquiry, it's a tough hill to climb, particularly under circumstances in which at the time that we initiated the third-party complaint, we didn't necessarily know what interpretation Judge Dason would adopt. As it turns out, the standard that she adopted, we don't take issue with, but it's higher than we thought it might be. Thank you, Your Honor.
Thank you, counsel. We've heard from the parties. We thank the parties for their briefs and for their arguments. The case is submitted. Right. We will take a 5-minute recess and return to call the third case. All right. We'll call the third case number 24 CV 298. Thomas RABON. Hopefully you'll help me with the pronunciation of your client's name versus PEPCO Holdings. And we're here now for counsel for appellant.
Good morning, Your Honours. May it please the court. My name is AJ Dali. I'm the attorney for the plaintiff appellant Thomas RABON. There are two issues in this case of disability discrimination and retaliation for claims under the DCHRA and the Coronavirus Support Emergency Act. The first issue for resolution is RABON's COVID diagnosis a disability. According to the EEOC guidelines on COVID, when here RABON was under medical care from October 2020 to February 2021, COVID is a disability. This will count that for 4 months he was receiving medical treatment, and then medical treatment, according to the EEOC guidelines, is not deemed transitory. Additionally, his doctors during this period, including Dr. Mary Ruffino, diagnosed RABON with shortness of breath, fatigue, and dyspnea, all of which the EEOC guideline states substantially limits respiratory functions and the major life activities of walking. The second issue for resolution is, did RABON show that PEPCO's reasons for his termination are pretext? As this court knows, PEPCO terminated RABON because he failed to provide adequate medical documentation for his medical absences, and that he failed his cable splicer test, which was administered to him on 9/15/2020. On the first issue, that RABON did not provide medical documentation to PEPCO, he did. They're part of the Joint Appendix 372 through 391. Even their own HR manager, Karen Gentry May, on page 64 of her deposition, Joint Appendix 516, admitted that RABON provided medical documentation.
Well, there's an ambiguity, I guess, in, it's certainly true that he provided medical documents, and I think that's undisputed. I thought their argument was that the documentation he provided was not adequate to support his assertion that he was no longer medically able to work. And I don't think, do you think that PEPCO conceded that your client submitted adequate medical documentation to support his claim that he was medically unable to return to work?
In the deposition, I believe they conceded that they provided, that PEPCO agreed he provided medical documentation. In the brief,
Which is, I think, undisputed that he provided. If you mean by that medical documents, yes, he
in
certainly
the
did.
briefs, it is my impression that they deemed that those medical documents are inadequate. Now, I guess then the question becomes for me, and perhaps even for Doctor, how does, I'm unsure how Dr. Mary Ruffino could make those records to be adequate. Because in those records, she states that he is suffering shortness of breath. In those records, she states that he has got dyspnea. In those records, she states that he's got long COVID. In the record, she states that the patient cannot come to work. And her last...
What do you deal with the particularly damning point from her deposition, though, that the idea that he couldn't come to work was really based on just what he told her and not her particular analysis? And I understand I'm summarizing a lot of very particular testimony there.
Sure. And I think that, you know, and so here's the thing, right? And we've all been to doctors. We tell doctors to a certain extent, I've got a headache, my leg is broken, so on and so forth. I think that was one of the questions I also asked Dr. Ruffino. And she briefly mentions that at part of at a deposition. She did not believe that he was faking this illness. In regards to Judge Howard's question as to, well, that was what the patient said. Those are, at least to me, you know, again, I'm not a doctor, that's part of the diagnosis of what a doctor asks a patient. How are you feeling today? What's wrong with you, right? The patient says, I've got A, B, C, D things that are happening to me. She had no reason to doubt that he was experiencing these things. And to me, at least, that is sufficient. At least also when we take into account what the ADA's Amendments Act's purpose is, which is to define disability broadly. It should capture his acknowledgement and the doctor's acknowledgement that this person is disabled and he's suffering from
Let me
long COVID.
slightly reorient you then. Under the DC Human Rights Act, you know, we have always interpreted that, and whether it's here at the Court of Appeals or at the Commission on Human Rights, it's always been interpreted, even before the ADAA, that, or the ADAAA, that to be broad like that. And so let's assume, for sake of argument, that you've established a disability based on long COVID, which is certainly possible. at that point if we're looking at the prima facie case, then he's already gotten the full DC FMLA, which he wasn't necessarily entitled to. Is he able to establish that he's able to do his job with reasonable accommodations at that point? If the accommodation is, I just can't work? Like, how does he get to that step of the prima facie case then, if you're successful on this disability point?
Sure. So I think the period where he says he can't work is from October 2020 to about February 15, 2021. That's when the doctor says he can't work. Personally, I think at that point, when there was also some email exchanges with the case manager Forrester somewhere around January 2021, January 29, 2021.
It was a little bit after the 16 weeks, which DC FMLA would have given him the right to, right?
Yes, but during that period, he also mentions, I'm not able to work. I have got long COVID. I think, at that point, PEPCO should have, at that point, PEPCO is made aware of his disability. PEPCO is made aware that he can't work. Personally, I think PEPCO should have also at that point perhaps engaged in the interactive process saying, okay, you can't come to work, fair enough. What can we do to make you come to work? That whole conversation never occurred.
But you're not arguing, this goes to the fundamental question of how to understand your discrimination claim. I didn't understand you to be raising a failure to accommodate claim. Have you been raising a failure to accommodate claim that he had a disability and they, instead of accommodating him in some way, they discharged him? I thought your argument was a disability-based discrimination claim that they wanted to get rid of him. Not that they didn't accommodate him, but they wanted to get rid of him because they believed he had a disability and they wanted to fire him for that reason. And they gave pretextual reasons about why they fired him.
The court is absolutely correct. I never raised a failure to accommodate claim.
Okay.
You're right.
So then the structure of the claim is, the structure, I mean, PEPCO's version of this is, their claim is, they don't think your client has COVID in a form that is a disability, and they don't think your client had COVID in a way that interfered with return to work. So they think your client was just not coming to work when he should have, and they terminated him for that reason. That's their picture. And that's their picture. I understand your picture is different. Your picture is your client did have a disability that was COVID. Your client, although PEPCO was claiming incorrectly that your client didn't adequately establish that. In fact, your client did adequately establish it, and inferentially, what was really going on is PEPCO is discriminating against someone who has long COVID by pretending he doesn't have long COVID and discharging him for not coming to work rather than because they don't like people who have long COVID. That's the structure of your discrimination claim?
That's exactly it. That's exactly it. And as I was going through the record yesterday, and I was looking at their consensus statement. This was made right after their March 2021 call, and it's on J8311, and it's under bullet point number 5. And this is one of the reasons for the termination. This is what it says, I'm quote, "The frequency or duration of tardiness and or absences for sickness is excessive, and the tardiness or absence is not protected by law." So what that tells me is that, among other things, why they terminated him was like, you know what, this guy's been out for 4 months. He really shouldn't. We really should not allow him to come back to work. They say that on their consensus form. So yes, that's absolutely my contention. I'll continue, I guess, at this point.
I mean, if you'd like a question on it, why, if the absence, like, what's wrong with that statement per se? Like, if the absences are excessive and not in line with law, if you are not making an accommodation claim that the time off was more accommodation, how is it retaliatory if he has no entitlement to leave beyond what he's already received?
So I think the issue is one of discrimination. I'm not talking about the FMLA issue, right? Under the American Disabilities Act and under the DC Human Rights Act, leave is a form of accommodation. I've cited the case law on that. If the defendant here, as part of their discussions to terminate him, is saying, well, one of the reasons we're going to terminate him is because he has been on excessive leave for too long, which under the ADA, he's allowed to do. That's protected activity. He can take leave. That to me tells me that they are discriminating against him because he took that leave. because he took that medical leave.
If they're wrong that he wasn't entitled to, if they're right that he wasn't entitled to, then they're within their rights in a non-discriminatory way to terminate him. So the question, I guess, is whether the information about the medical records and what PEPCO said about it and stuff on the pretext question is whether a reasonable fact finder could look at all the medical information that PEPCO had and its explanations about why it didn't think it was adequate and think not just PEPCO was wrong about that, but in fact, PEPCO is not telling the truth that that's its reason. Because I think you would agree that, let's say there's conflicting information about whether someone is adequately recovered from a medical condition that amounts to a disability. So we're in the context of the discrimination statutes. And the employer looks at it and in good faith says, you know what, I think that the employee can come back. Employee says, I'm not coming back. And the company says, well, we're going to discharge you because we think you can come back and you can't. The issue, if it's not an accommodation claim, the issue for discrimination is not whether the company was right about that. It's whether the company was wrong about that in a way that permits an inference that the company was lying when it said that was its reason. It wasn't doing that in good faith. And in fact, it was acting out of hostility towards someone for having the disability that the person had. Is that, do you agree that that's what the issue on the pretext is? It's not whether PEPCO was right or wrong. It's whether a reasonable fact finder can infer that that wasn't really PEPCO's real reason. And really, they just don't like people with that disability.
I believe that's my contention. Yeah, that's my pretext argument that they just.
I'm just asking, that's what you are required to show, is that to survive summary judgment, a reasonable fact finder could look at these materials and say, not only is PEPCO wrong, but inferentially PEPCO's lying. That wasn't its reason. It really just doesn't like people with this disability. That's your burden.
Yes,
to persuade about what a reasonable fact finder can infer.
Yes, absolutely.
And if you were going to try to explain, I mean, I take it from the briefs and the trial court's ruling that there's not like a smoking gun piece of evidence where PEPCO says, you know, we really hate these people with COVID or anything like that. So there's not a smoking gun. So it has to be that PEPCO's statements, you know, if you look at the medical records as a whole, a reasonable fact finder could think PEPCO wasn't acting in good faith. And if you were going to, I know you have said that there are some things that are favorable to your client in the medical records. I'm not sure you've acknowledged yet some of the things, other than there was a question about the testimony of the doctor, but there were some other things in the medical records about your client running 2 miles a day and things like that that seem as though they would tend to support at least the reasonableness or authenticity or truthfulness of PEPCO's decision. So if you were going to say, if you look at the medical records as a whole, a reasonable fact finder could conclude PEPCO's lying, they're not acting in good faith. How would you square that with what seems like some materials in the medical records that supported PEPCO's conclusion, even if you think they might not on the day carry the issue, if that were the issue?
Sure.
So what's your case about why PEPCO was so obviously lying, that sufficiently obviously lying that a fact finder can infer that?
Sure. Okay. I'll address the issue on, PEPCO's line. During the deposition, I asked Karen Gentry May, their HR persons, whether they reviewed the medical records, because supposedly that was the reason for the termination. Hey, you did not provide adequate medical documentation. They admitted that, no, we did not review any of the medical records, which at this point then begs the question, if you did not review the medical records, why did you fire him for lack of medical records? So I guess that's my contention, that they're absolutely lying. That's one. Going back to the issue about, the medical records are somewhat, conflicting. He can walk 2 miles. He's got long COVID. What really does he have? And my, contention on that is, and I think the example I used was with cancer and Parkinson's and so on. Cancer patients can run 2 miles. They can, climb up a staircase. That doesn't mean they don't have cancer. That doesn't mean that they are.
But the issue isn't whether your client had COVID or long COVID. The issue for PEPCO was, if it's not an accommodation claim, the issue only was, did your client have it in a way that prevented his return from work to work? So that's so I'm not sure the analogy is good. I don't think anybody's saying necessarily. Again, the issue isn't whether your client did or didn't have COVID or long COVID in some sense of that term. The issue relative to this would be whether PEPCO acted so obviously unreasonably in thinking your client was fit enough to come back to work, whether he had long COVID or didn't have long COVID, that it must have been lying when it said it thought he couldn't come, that he should be back at work. And instead it was using that as a ruse to get rid of somebody who they really thought had a disabling version of COVID.
Sure, and like I said, you know, we can go back to the record based on their reasons as to when, as to essentially their reasons saying that, you know, we are terminating RABON because of lack of adequate medical documentation, when they never even looked at the medical documentation. In order to show pretext, I need to show that their reason is a lie, that the reason PEPCO has asserted is false. I've shown that. You know, another way I can show
Can I ask you
pretext.
just to make sure I zero in on what where in the record you're relying on? You say that during a deposition, you asked someone from PEPCO about review of medical records, and the person said no one at PEPCO ever reviewed medical records, or what was, and
Sure.
so can you point me to exactly?
Sure,
Just want to make
that-
sure I know the testimony.
Yes,
you're referring
that
to.
is on.
If you don't have it ready to hand, I don't mean to hold things up. You can let us know.
I know it is in my brief. You think I would have this if with the court.
You can let us know
Yeah,
in
let us-
rebuttal too, but I also want to give you the opportunity to answer directly and not eat into your rebuttal time. You know, speaking on this retaliation point, you've talked about temporal proximity, and I want to ask you about that when looking at these medical records too. What is your client's answer to when we look at the medical records, we see that the diagnoses happen to conveniently change whenever the temperature in the water turns up. So January 26th is the date he's told, well, you know, your time's up, but then it's January 27th, he's now gone to the doctor, and it's where we're saying, oh, he can't return to work, or we've got a conference scheduled for February and mid-February, and it's all of a sudden now we see, okay, well, you can return to work now on that. Well, what's your client's response?
Sure, yeah, and yeah, and I addressed that in my brief too, right? Because when in January 26th, I think was his last communication with the case manager Forrester, and she goes, oh, you know, you need to come back to work and you don't have adequate medical documentation. I think on 2 days later, January 27 or January 28, 2021, he sends her an email saying, look, here's my doctor's note, and the doctor says I still cannot come back to work and I need to be reevaluated in a month. And then at that point, I guess the case manager says, well, you must come back to work. As an employee, you know, at that point, I think he's just, you know, and this is again, as an employee, a low-wage employee is all like, well, geez, I'm gonna lose my job, you know. So he goes, all right, well, if they're telling me I need to come back to work and clearly I need my job, he's gonna do whatever he's going to do to get his doctor to, I guess, you know what, send me back to work. I'll just go deal with it, whatever happens to work. I think that's really what just played out in here, because PEPCO, at least the way I read the record, seems to be pressuring him to return to work. His doctor has clearly said, you're still not fit. Yeah, but you know, they're like, well, you've got to come back. All right, fine. He picks up the phone and says, you know what, these guys are bugging me to come back. So, you know, I think that's kind of what kind of happened. Personally, I believe, and of course this wasn't explored, if PEPCO, and I've had this, you know, with some other cases, CNN actually comes to mind. Daughtry was a CNN Federal District Court in DDC. I think another employer, rational employer, would have said, you know what, Mr. RABON, take as much time as you need. We want you back here healthy, safe, and you know, not having any kind of COVID complications. They did not do that. They pressured him to come to work. So then he pressured his doctors, all like, you know what, these guys want me back to work. Give me something. And I think that's really what kind of explains that in here.
I know you're over time. I don't remember you reserving time for rebuttal. Am I forgetting? And you did?
I did. I'm sorry if I didn't. 2 minutes.
That's fine. And let me just say one other thing, apropos, it looks as though from your reply brief, at least, that the testimony you're referring to about not reviewing records is at the joint appendix at 517. It seems to be that one particular employee,
Gentry May, I believe.
Gentry May, said that, I don't know if that is a man or woman, didn't see that documentation, that the terminating panel never did. I don't know that that's what no one at PEPCO ever did. And I thought that Ms. Forrester, who I know was not a medical professional, was reviewing the medical documentation. So maybe they relied on her conclusions. I don't know. But is your assertion that that no one at PEPCO ever reviewed that, or just that the decision makers didn't independently review it?
It is my assertion that the decision makers, based on Gentry May's admission, did not review the medical records.
So I think we know that. I don't think that's a homework assignment for your rebuttal because I think I've got that zeroed in. Okay, thank you. All right, we're here now for counsel for PEPCO.
Thank you, Your Honor. May it please the court, Susan Carnell on behalf of Potomac Electric Power Company, PEPCO. Let me start by responding to a couple of points that came up. Mr. Rabon's counsel said that he thought that there was evidence in the record of an actual intent to discriminate against people who had long COVID. And I want to point out to you that there is factual evidence in the record that as of March 2nd, 2021, sort of the last record date we had right before around the termination date, PEPCO had had 135 employees out on medical leave for COVID of some variety, long or short. At the time of the decision, 129 of those 135 had been successfully returned to work. The remaining, one had retired while out on leave, 4 were still out on approved leave, and Mr. Rabon was the only employee that PEPCO was unable, as of that moment in time, to have successfully returned to work. I think that actually is evidence of the absolute opposite intent, not an intent to discriminate against people with COVID. I also will just raise a point about that picture in the record we were just looking at with Ms. Gentry May. She is an HR person. She reports to Marsha Bias. They were both deposed. They both testified to the fact that the Human Resources Department does not review records and PEPCO, that the Occupational Health Services does, that they rely on the medical assessments conducted by the Occupational Health Services. In this case, there were 2 people who gave sworn testimony from the Occupational Health Services. Angela Forrester, who interacted with Mr. Rabon for much of the relevant time, and Kathleen Thompson, her boss. Ms. Forrester is a registered nurse. She subsequently got a degree in nursing. Ms. Thompson is a nurse practitioner, and they both had communications with Mr. Rabon about returning him to work. You could argue, if we were here on a reasonable accommodation case, that in fact PEPCO did engage in that interactive process when not only did it talk to Mr. Rabon about returning him on January 29th, it reached out to his doctor and enlisted his doctor's assistance in calling him on February 2nd and saying, if you can go back for 4 hours a day, they won't send you a job abandonment letter. He didn't. They sent the job abandonment letter. So back to the Ms. Gentry May point, what she says in answer to Mr. Rabon's counsel's question is there is a reason that she doesn't review the records, and the reason is separation of duty. They at PEPCO feel very strongly that the medical information should be held as private as possible, and therefore they rely on their occupational health services to evaluate the medical records and to tell HR and other decision makers whether this person is ready to return, whether this person counts as disabled under the short-term disability policy, not under the law. And in this case, whether or not the note he provided on February 18th that had allowed him to return to work 4 business days earlier was sufficient to justify his extensive absence without excuse. And what there's evidence in the record, what Marsha Bias testifies to, what Kathleen Thompson testifies to, is that Kathleen Thompson reviewed that note and said, unsurprisingly, all it does is release him to work. It provides no justification for his extended absence without leave. So I think turning now back to sort of the argument that I had intended to make, it's quite clear that you are well familiar with the record. You are well familiar with the reasons that PEPCO had for his termination. He violated the job abandonment policy multiple times over. He violated the job abandonment policy even in that short window of time between when he got the note from Dr. Ruffino, releasing him to go to work, and 4 days later, when he first raises that release note to PEPCO. And how does he bring it to PEPCO's attention? It is only when someone from PEPCO calls him back. He has sent in a note through an all-call line to PEPCO complaining about his treatment, and an HR person who had not previously been dealing with his termination or his being out, she's tasked with following up on these employee comments. And she calls him and says, I'm calling you to follow up on these comments. And he says, well, I've got this issue. I'm going to have a termination call tomorrow, and I have this note from my doctor. And she says, well, send it to me. So he does. That's the first time he brings it to PEPCO's attention. He was absent February 15th with that note. He was absent February 16th with that note. He was absent February 17th with that note. He was absent the day of February 18th with that note because he doesn't get the call from her until like 7:40 in the evening. So even if we limited it to just that period of time, he has in his hot little hand a note that says he can go back and he doesn't tell PEPCO about it. PEPCO's job abandonment policy is 3 days. He had violated it before they sent the first letter on February 3rd. And that's the moment in time when the intent to begin the process of terminating him for job abandonment starts. And at no point after February 3rd does he provide any reason for PEPCO to reconsider that finding. Mr. Rabon's counsel makes some points about the facts in his brief. And let me just turn to the other counts that we haven't talked about for a moment. I think for one thing, the first count I wanted to talk about is count 3. I think that's the simplest one to get rid of here. The Coronavirus Support Emergency Act claim does extend the FMLA to people like Mr. Rabon who'd not been employed long enough to be covered by the FMLA. But I do think that it would be a service to the District of Columbia to clarify that it only provided quarantine leave. It did not provide to people like Mr. Rabon 16 weeks of leave for caring for himself, because that has been what Mr. Rabon's counsel has argued in this case. And I think the statutory language and even the guidance is clear that what that protected was the 14 days of quarantine leave. For this reason, certainly there are other reasons applied, like caring for children whose schools have closed, but those aren't at issue here. And that's where I think you could possibly get to 16 weeks. But in this case, we're looking at leave that was taken between October 8th and October 22nd. He took that leave. We gave him well more than that. We gave him more than the 16 weeks, as Judge Howard mentioned. And it's clear that we didn't terminate him because he had taken that leave, which ended on October 22nd. And for that reason, I think that's the easiest count to get rid of here. The disability discrimination count. We've talked a lot this morning about the medical records and how you read the medical records and whether PEPCO was in good faith reading the medical records in such a way that showed that Mr. Rabon should have returned to work on or about January 26th. And I think the record is absolutely clear that that was a good faith decision by PEPCO, and specifically by Angela Forrester and Kathleen Thompson, who are the ones who made that decision. They specifically warned Mr. Rabon before he tried it in January 13th, that a note from your doctor saying you can stay out is not going to be sufficient. We're making a judgment on a disability policy as to whether you get to stay out, and it has a different requirement. It requires that you be fully disabled from your job. And if you're not fully disabled from your job, we're not going to justify your absence, although they were prepared to give him light duty. The medical evidence shows that the medical exams were consistently normal. Yes, he complains of dyspnea. Yes, some doctor told him dyspnea could continue for 6 months. But so for one purposes, I think it's clear that PEPCO's decision that the medical evidence did not support his continued absence is absolutely, it's correct. If it's not correct, it's in good faith. And it's certainly not evidence of discrimination. There's an even more fundamental question that I would urge this court to find. And that is, it doesn't show that he was substantially limited in any major life activity as compared to the average person in the general population. There is not a scintilla of evidence in this record that talks about his limitation as compared to an average person. Mr. Rabon actually was asked that question in his deposition, and he didn't even bother to opine as to whether he was substantially limited as compared to an average person. And Dr. Rich Spino did not testify to that either. So even before we get to whether or not PEPCO should or could have made this decision, in fact, you have to answer, why are we here? This fundamental threshold question. Has he pled, has he shown at summary judgment, has he provided any evidence from which a fact finder could find that he was actually substantially limited? And I think the answer to that is no. There's no evidence of substantial limitation. PEPCO is not asking you to find that COVID could never be a disability. Of course it could be a disability. We never took the position that it could not ever be a disability. What I think Mr. Rabon's counsel wants you to find is that it is always a disability. If a doctor writes long COVID in his notes, you're disabled. And that's not the law. That's not what the EEOC has ever said. That wouldn't be true under the ADA, and I don't think it's true under the DCHRA.
On the related disability point of not this long COVID point, but the invisible learning disability.
Yes.
This was debated in the briefs, but I'm wondering if you would concede that on this record where your client granted the accommodations, did all these other things, and presumably was willing to grant the accommodation, and now they're willing to grant the accommodation if he came in to take that test again, the cable splicer helper test, progression test, excuse me, that would be sufficient to consider him as regarded as disabled in that respect. Is that a concession you'd be willing to make today?
I don't think so, Your Honor. I don't think that the plaintiff has actually litigated this as a regarded as claim. And I think that PEPCO was clearly willing to give him the accommodation, but they were willing to give him that accommodation without even evaluating any medical evidence at all. So there's two time periods at which PEPCO had expressed a willingness to provide him with accommodation. There was the hiring in August of 2019. That was actually, he was interacting with someone in Chicago. And
he provided the IEP, and
he
she
provided
said
the
that was
IEP,
enough.
and that form, which is a reply exhibit, is specific to it being hiring. Like, this is for hiring new members. It's clear that on its face that it's not about employment accommodations. And then there's the period of time. So she asked for that. She provided that. She doesn't have any further follow-up in any decision thereafter. Then when we get to September 21st, when he tells us that, well, when he learns that he failed the test, and he tells someone in DC that he needed an accommodation, and they learned that there was accommodation provided, I don't think that admits that they regarded him as disabled. They were willing to provide the accommodation he requested. And I think it's a danger if you start to disincentivize employers from providing accommodations that maybe they're not legally required to do so, by then saying to provide the accommodation would be then to waive your right to argue that the individual isn't disabled, or would be then to admit that they are regarding you are regarding them as disabled. That will, I think, in effect, say that employers they're going to have to go through every rigorous step before allowing accommodations, for fear that they will then be sort of on the hook for the regarded as disability. And I think if we look at it under an actual disability claim, which is, I think, where it has been litigated in the case, except for maybe in a footnote in Mr. Bowen's counsel's brief, that there isn't evidence in the record of an actual disability. The only evidence in the record comes from a Department of Education document and Howard County Public Schools documents that those statutory schemes of providing accommodations in schools, without even doing any research, I think we could all agree is very different than the remedial scheme that is provided in the DCHRA to allow employees to continue to work with accommodation, and to ensure no discrimination against them on the basis of their disability. We don't know what information. I mean, I don't think it's a self-authenticating document. It seems at parts to be a draft. I think we don't know where it came from. We certainly don't know the information they relied on to come to that conclusion. And I don't think we can just assume from that document that he is disabled within the meaning of the DCHRA. But again, I don't think that means you need to find that no one with a learning disability would ever be disabled. I think that Mr. Rabon could have put more evidence in the record. If he had wanted to make an actual disability claim with respect to his learning disability, he should have brought in medical evidence. He should have brought in psychological evidence, neuropsychology evidence of a learning disability, if he had wanted to say that we actually discriminated against him on the basis of learning disability. I don't think there's any evidence in the record that we did. I think there's actually evidence in the record that we did not. I will point out one sort of procedural and factual issue together. We actually included in our statement of facts, which is the way, the record is supposed to be developed on summary judgment, defendant's fact 39, where we talked about motive and intent. And we talked We had, as our record citations, affidavits from Karen Gentry May, the person who made the initial recommendation to terminate. We had an affidavit from Abdullah Karkbo, the manager of the department that Mr. Rabon worked for, about his motive and intent when he recommended with Karen Gentry May to make the termination decision. And we had also, I think, a declaration from Marsha Bias about what she had spoken to him on the phone and what her intent and understanding was. And they denied using disability, his leave, his learning disability, his request for testing accommodations as part of their decision-making. And what did Mr. Rabon and his counsel do in response to that fact? They threw up their hands. They didn't add any citations to records. They said, this all proves it's discrimination. And I don't think that's an appropriate procedural way to go about. I think if they had facts to point to a discriminatory or retaliatory animus here, they should have included it there, and they did not. We talked about it in terms of, oh, I'm sorry, I see that I've run out of my time. If you have any further questions, I would be pleased to answer them. Thank you.
Thank you, counsel. We're now from Mr. Shelley in rebuttal. I think negotiated 2 minutes, perhaps.
Yes, 2 minutes, Your Honor. I'll quickly answer the last point about us not rebutting their claims about discrimination. I think what Ms. Carnell was implying there was express evidence of discrimination. We do not have express evidence of discrimination. Discrimination, as this court knows, can be shown through direct evidence. Hey, I don't like you because you're disabled. We don't have that. Or through circumstantial evidence of discrimination, right? How do we prove circumstantial evidence of discrimination? That their reasons for the termination is false. I've shown that. They've provided 2 reasons for the termination. That A, you did not provide medical documents. He did. And B, you failed the cable splicer test on 9/15/2020. As I mentioned in the record, while he did fail the cable splicer test on 9/15/2020, they then provided him accommodations to retake the test on 9/25/2020. They then also penalized him for almost seeking accommodations by using it as grounds to then terminate him. And when you look at the suspension
Wouldn't a fair way
letters-
of looking at it be that they didn't penalize him for seeking the accommodations on it? There's nothing about his COVID, like shortness of breath or fatigue. Why would that stop him from having requested to take that test at any other point over that 6-month period?
Because he was on short-term disability leave. I mean, he was, he was rescheduled to take the test on 9/25/2020. He was, the last day he showed up to work was on 9/23/2020. He's out from 9/24/2020 all the way until January 26, 2020. He's right. His doctors say,
And then for a month and a half, he doesn't put in any sort of request or anything to take this test to move along or to come back part-time as they offered to him, right?
I believe there's also, PEPCO at that time also did not say, hey, you know what, you've been out for 4 months, why don't you come and take the test on February 1st, January 27th? I think the burden applies both ways. I don't know, personally, I don't know who moves the ball there. But I think,
Isn't another way of looking at it, even if no one faults your client for not having arranged to take the test during the period he was out on short-term disability leave, or even at any point other than, I mean, one way of looking at it is PEPCO is saying, we terminated you because A, you didn't come back to work when you were supposed to and could have. And by the way, B, because you didn't come back when you could have, you haven't passed a test that you had scheduled to retake. But instead, because you didn't come back to work, you haven't passed that test either. And so that's why, as a whole package, we're terminating you. That makes it not really so much independent of the failure to return to work. And if it's viewed that way, it doesn't seem as though it's penalizing your client in and of itself for failing to have passed the test. It's just sort of like, it's particularly problematic that you didn't come back to work because during the period when, what that means is you haven't passed a test that you should have passed. We're going to give you another chance, but now you don't show up to work and you haven't passed that test either. What's wrong with that way of looking at it? It's not sort of penalizing, but just explaining the why it's particularly problematic that your client didn't return to work because he now he lacks a qualification that you'd be supposed to have in order to perform that work.
I also want to be clear that on January 26, 2021, when he had that conversation with the case manager, I'm not sure of anywhere in the record where they say show up on January 26, 2021. I think at that.
This is not really so much about his missing the test because of illness on that first day. It's more at the back end saying, let's assume your client legitimately missed the test, but the problem is, and they were going to give him an accommodation, but there was a time in which he was going to do that and he should have come back to work to do it and he didn't come back. And that means not only is he not back at work, but he couldn't pass the test that he was supposed to have passed.
And I think that goes back to what I responded to Judge Howard. He was on short-term disability leave. I mean, I'm kind of unsure,
Well,
what.
I understand that makes, but if PEPCO's, I mean, that's not true for assuming that PEPCO is treated as conceding that he was appropriately not at work during the period of short-term disability leave. That's not the whole timeframe, right? That ends a fair bit before the time when they discharge him. And their view is, here's a whole period of time when he's not on short-term disability leave. He should have been back. He wasn't back. During that time, he didn't take a test that he needed to take that had been rescheduled originally. That's part of the reason why we're discharging him. I don't see why short-term disability leave is an answer to that line of thinking.
And I think that time period where he's not on short-term disability leave, that's after January 26, 2021. And my client's position is that after January 26, 2021, he went back to his doctors trying to get back to work.
I understand that. My only point is this way of looking at PEPCO's ruling makes it not really independent of it having a legitimate reason, which is your client didn't come back to work when he should have. And if that's a legitimate reason, I don't think it's additionally problematic for them to point out. And one of the consequences of that was that there was this test that he needed to have taken that he tried to take, he failed, we were going to accommodate him, it was rescheduled, he got sick. But he hasn't taken it still, even during the period when we're saying he should have been back at work. That's part of why we're discharging him, is he's not back to work. He doesn't have a test that he could have gotten during a period when he's back to work. I mean, I understand your point that your view is that their first reason that he should have been back to work during that period of time is not correct. But if it is correct, then I don't see the second reason as independently problematic, is the point I'm trying to explore.
And my contention is that they are just not correct. Yeah.
Okay.
I see my time is up. I don't know if there are any further questions.
All right. We thank counsel for their briefs and their arguments today, and the case is now submitted, and we will stand in recess.
All rise.